I'd like to call the second October meeting of the Rules Committee to order. Please note for the record, Alderman Arnett and Alderman Savage are in attendance. And we're joined by Assisting City Attorney Gary Elson and Planning Director Pete Gutwall. First item of business is approval of the minutes from the October 2nd meeting.
Move approval of the minutes. Move approval of the minutes.
I'll second.
Any amendments, corrections, additions? Hearing none, all in favor, please say aye.
Aye.
All right. First legislative item is 01418, Development Review Process Amendments. Who would like to take the lead on this? Do we want to invite Mr. Hyatt up to the table with you? Since the three of you are responsible for going back to agree on the amendments to the language.
If I recall, we landed on amendment number 2 was where we were trying to work out the final language.
Would you say that again, Mr. Gutwall? Is your mic
I'm
on?
sorry. Amendment number 2 was the one we were going back and forth, and I think we forwarded that to Rules. Mr. Hyatt forwarded that to the Rules Committee.
I think
for
we
their
did.
review.
Is that under Rules and City Government Proposed Amendments from 9/5/18?
Trying to remember.
Yeah, that's a good question.
I think
Alderman Savage.
Thank you, Madam Chair. I think we may have approved Amendment 2 at our last meeting.
I thought we sent you back to address number 2, that we had already approved amendment number 1. I thought there were more than 2 amendments, though.
You approved
We
1,
did.
3, 4, and 5,
Right.
and then 2 was still needed.
I'm
think-
looking for 3, 4, and 5, and I'm seeing amendment 1. You have a hard copy.
I have, because this is such a mess, I have a hard copy because I couldn't keep track of it otherwise.
Can we very quickly go through these so we're all on the same page, though?
Sure.
The first amendment is from page 2, lines 13 through 42. And Ms. Green, correct me if I'm wrong, we've already agreed on that amendment? Okay. And then amendment number 2 is page 3, lines 31 through 40, and that's the one we're still
Oh, that's
working on?
right. Yeah, I think we spoke about removing one of the footnotes from Amendment 2, is that right?
Well, I don't know, that's what I'm trying to clarify, gentlemen, what do you have that we, or Ms. Green, maybe I should ask,
Well, I think Alderman Arnett had proposed some changes in there having to do with that footnote, and they were going to take that back.
I think
Well,
there was just a minor change in D.
In letter D?
1D, where instead of mailing address, you put geographic boundaries, right?
I'm not seeing D, to be honest with you. I
I'm-
see B, Amendment 2B.
It's
What
not the
page?
amendment number, it's paragraph 1D, as in dog, 1D. That's
What
that's under
document are you-
Amendment 2.
Okay, what page and line?
That's page 6, lines 26 through 46.
What?
Okay, so that's on page 4 out of 9,
Right, I
is
think
what
that was
I'm
the only
looking
one.
at.
Yeah.
Page 6, lines 26 through 46.
Mhm.
That's right, yeah.
I don't know if I printed that out.
Okay.
And I don't want to go backpedaling, but on that page 6, 1B, it's property owners and tenants of property located within 200 feet. We may have talked about this because it's been so many times we've been here. It's hard to ascertain tenants because, within 200 feet of the subject property, I can give you an example. Somebody could be living in a basement apartment, for example. I mean, we get our information from the State Department of Assessment and Taxation as to who the property owners are, but there's no way of knowing tenants. And so, it's a concern that property owners and tenants are supposed to get notice. Now, we can cure it by just sending a letter to all tenants located at such and such a address, and just send it to every address within the 200 feet. But it's just not really ascertainable is all I'm saying. And I don't know whether you want to leave it in there or...
Is it doable? I mean...
It's not really, I don't think you can identify the tenants within the 200 feet. All you can do is identify a class of tenants, or, meaning a notice would go to an address that says property owner and tenants at a certain property address. You just don't have a register of where to get a list of tenants to send notices to.
For your purposes, you're home free on this. We've agreed that the city is going to provide the list, and typically it is. I mean, whenever I've needed a list, I've gone to Sean Wampler, and she generates a list that goes on the envelopes.
Well, the tenants, no, I think the city's going to provide the homeowners associations, right?
Right.
Just that part.
But how do you do the 200 feet now? We're not changing the 200 feet now.
Well, we're adding tenants. I mean, the property owners within 200 feet, we get by doing a radius on a map that the State Department of Assessments and Taxation has, and we give notice to everybody who owns property, and we can ascertain that. What I'm saying is there's no way to determine tenants within 200 feet.
I'm still having a hard time figuring out where you are.
Yeah, I can't find the
Oh,
tenants.
it's
Where that's
page
Capital B.
6.
No,
the
small b, 1B.
Page 4, it's page 4 of 9 of the amendments.
Okay.
Under Amendment
Page
2,
Go back
4.
one
it's
more.
page 4,
Page
you'll
And
see
it's
it.
4.
one little b.
And then you'll see page 6,
That
I
one
line
have a
will
20.
show.
one B on page 4.
Oh, I see, okay.
What's this page 6 mean?
Ross, you're,
Okay.
Okay,
make
here.
sure you're looking at the right amendments.
Okay, so this is
The ones,
my page 4.
the ones on the, Granicus or whatever are
Page
the
4 of 9.
And
most
it's
up to
page
date.
Still-
6, line,
No, they just said go to page 4.
Okay.
yeah, it is page 4.
Page 4 of the amendments.
What's that page number?
4.
Okay.
I don't have a little b.
I'll come up if you want to
It's
and
page-
show you the document that we're referring it to.
That's
Right
not
now.
the same document. Go out.
This is the document that's in Granicus.
Yeah, I still don't see this with
Well, I just
tenants
put it up
in there.
Granicus too, so.
Okay, you're in the legislation.
Mine
you're
shows
not in
page
the
4 of
amendments,
9.
that's the problem. It should be the Rules Committee amendments, that's where you need to be. Down,
There's just the tenants that.
scroll. Yeah, there it
All
is.
right.
And go to
So-
page 4.
Oh,
So it's the Rules Committee amendments, it's not the legislation, that's where you guys are.
So B, property owners and tenants of property located within.
So I would just add, we were just doing this exercise, and the issue was, we have property addresses, we just don't, there could be, he was giving examples of residential, but in commercial properties, you have suites A, B, you may, suites 1, 2, 3, 4. whatever, all we have is the property address, we don't have the number of suites and who those tenants are. So when Sean's been doing the notification has been just going to the property owner. One of the ways we can deal, and tenants, is we can identify, one of the ways that we've been doing it is there's the property address, and then there's the premise address, and then there's the mailing address. And the mailing address would be the property owner, the premise address would probably go to the tenant if you're dealing with residential units. The issue is when you have multiple tenants at one address, that's not an easy, that's not gonna come up in GIS. Go ahead, Mr. Savage.
Well, I'm just wondering if we're overthinking this perhaps, because I think we could overcome a lot of the potential ambiguity there by just basically just drop them off, deliver them to the addresses, the actual physical properties, and then you'll get whoever owns it, whoever lives there.
Right.
Well,
We can do that. I mean, we could just send a letter to, you know, if it's 123 Main Street, just send tenants, 123 Main Street. I mean, you know, we're just not gonna be able to ascertain who they are. I don't think it's, you know, a killer one way or the other, but I'm just telling you, we would not be able to send it to a specific tenant, because we're not gonna be able to know. Like,
Come on up.
But that
Grab
list
a
is.
chair, come on up, join the party.
I just went through this, so I think I.
Could you get on sir, could you get on a mic and identify yourself, please? Pull up a chair or stand at the podium, whatever you're good with.
I just went through this process and I've been on both ends of it.
And you are?
I'm Brian Toomey, I'm at 424, 428 4th Street in Eastport,
Thank you.
Alderman Arnett's district. And I have multiple tenants in my 424, 428 building. And when 418 went to do a community meeting, they sent notification to us at all our addresses, but made out to us as the property owner. Well, from all the different addresses, well, if it's made out to us as the property owner, how is the tenant gonna get it? To me, it would be very clear if you just made a requirement of the property owner to notify the tenants. Would make more sense, because on another note, when I did a community meeting.
Turn your mic on.
So on another note, when I did a community meeting just recently, and Ross was in attendance, and I called planning and zoning and said, I need a list of tenants of all the commercial properties within 200 feet. And nobody can provide me that list. Now, there's tenants that are subletting in some of those commercial spaces. It's nearly impossible to have an accurate list, to do it properly, of all the tenants of all the properties within 200 feet. I mean, I don't know how you do it. I think when you notify the property owner, why can't you just put the onus on the property owner to notify the tenants at that address?
Oh, that would make sense. Gentlemen,
What I
Delson?
would say, this is Gary Ellison, Assistant City Attorney. I totally get the fact that you can't identify a tenant by name, because to try to figure who that would be, you'd have to see the lease between the landlord and the tenant, or the owner of the building and the tenant. But we can, I wouldn't put the burden on the property owner here, because the property owner is just getting notice, and is not necessarily even interested, it could be interested in the application. But to me, the developer has the burden of notice, proper notice, and we shouldn't transfer the developer's requirement of notice to a property owner who may not even be interested in the application, and we can't even guarantee that the property owner would do that. With the developer, we sort of can guarantee it, because the developer usually provides an affidavit saying, on such and such a date, we gave notice to whoever. So I would keep it with the developer. That's my recommendation. But I would say on the tenant thing, you know, essentially when it's rented, and that they can figure out generally, because we have rental applications, and you know, we know which buildings are being rented and which buildings are not being rented. Not commercial, just residential, that's true. But we
not all residential, unfortunately.
Right, and we can simply, and Alan was saying, you know, maybe, you know, in response to you, Alderwoman Finlayson, that we could, they could be hand delivered to say an office building has 5 units in it, and they can hand deliver 1 to each unit. Or they can just send it to, when we know that there's a mailing address of an owner that's out of state or out of the jurisdiction, it's clearly a rental. If you just go to SDAT and you can find out if the owner's mailing address is somewhere else, that usually means that there's a tenancy there. And we can just, have the mailing go to the address, the actual address of the building, and then the mailing address of the owner. And so therefore, I think you've got it covered with owner and tenants, although we're not identifying any tenant by name.
I think we're saying the same thing.
Yeah.
I think the conclusion from what I hear is we can't possibly get every tenant because we don't have a database and it changes too quickly, I'm sure.
Right.
So the tenant or the owner should be the one who gets the letter and gets the notification. And if you have access to the tenants, then so be it, but it is the owners, I would think, that would have the most interest.
Right, but sometimes there's tenants in there they're on a 5-year lease if it's a commercial building, or a 3-year lease. I think the notice should go to the unit, but not identify it could be occupant or tenant or something like that it's mailed to. But, the owner could be an absentee owner and not interested in anything, but the tenants have a long-term lease, which could be 2 years, 3 years, 4 years, and they might be interested. And so, go ahead, Rob.
So
wait. Yeah, I'm sorry.
So we want to first send it primarily to the property owner. And then if we have access to a tenant list, then we would include, when I get things that say occupant on it, I throw it in the trash can.
Right.
Because I figure that's not me. If they,
Well,
So-
I'm just not sure how else to do it other than to, even if we
I
hand
have a
deliver it.
suggestion.
okay. Go ahead, Ms. Dell.
Even if we hand deliver it, it still could get thrown out,
Yeah.
So the thing is that we try to cover it as best we can. So if the owner's absentee, we send it to the owner, whether the owner's in, Silver Spring or Utah. And then we know that by SDAT, that the mailing address of the owner is such and such an address. And then, if it's clear that the building is not owner occupied, like, in other words, a commercial building, there may be a situation where the owner has an office in the building. We're not necessarily going to know all that we just, hand delivery is one process, or certified mail to each unit. So like, 1 Main Street, Unit A, 1 Main Street, Unit B, and we could require the notice like that. I don't know.
Did you?
Please,
Alderman?
well, let Rob, but I'd like to speak to this, but Rob has been waiting.
Well, you were first. I keep
Oh,
you in
all right.
order, so you.
Look, we know the address, and from SDAT, we know the address of the owner. It seems, I don't want to get into hand delivery. I think that's too onerous. We've already long ago abandoned doing the certified mail. Just send it to both addresses when there's 2 different addresses. But what I'm really trying to get at is, what are we trying to remedy? Is there a concern that someone later on will come up and say, I didn't get an address, and you'll get sued? That's why we agreed to put the onus of this on the city. The city is providing the addresses. And in this legislation, Brian, the city has taken over that responsibility so that you can't get sued. If there's anybody at fault, and believe me, Mr. Gutwald didn't want to take this on because he also sees the same thing you do, that this is a burden and a pain. But we took away with this legislation, actually we did it in 03517 because Alderman Budge and I recognized this concern, and we said, you will not be held liable by that because we're giving you the list. And the list we give you will have both the address and the owner's address.
But
I
I
don't
think,
think that's
Ross,
right.
I think it states that it's coming from the mayor's office, so that it used to
Right.
come from planning and zoning. So where in the mayor's office are you obtaining that list?
So this is an obligation that this legislation gives to the mayor's office because there are other reasons why
Yeah.
the city needs to know this information. And so it falls to Janice. I thought it was gonna go to Will Rao, but apparently they've decided Janice will have it. So
That's not right.
this is a master list that the city is maintaining.
Well, what
It's-
Janice has accumulated or coordinated is all the homeowners
Right.
or all the associations
right.
within each ward.
It's the community associations and homeowners associations that we get from the mayor's office in this legislation. The property owners and tenants aren't supplied by the city.
But I'm still trying to figure out what the problem is. You
Well,
know the address of the property, and from SDAT, you also know if there's an owner that isn't resident there. What's the problem?
Here's my concern. If a tenant in a property within 200 feet doesn't get the notice because we haven't identified that tenant, because we can't identify that tenant, then that tenant could come forward and say, hey, I didn't get notice of this hearing and it's invalid. It's unusual.
Have we ever had that happen?
I've had it well, let me say this. This is the first time we've ever had tenants that get
Well-
notice. I mean, I've never seen tenants get notice. In the county and in all of our other notice requirements, the property owners get it because it's ascertainable. I think this creates a risk, and I think it can be,
Right.
I think it can be covered by just sending to every single address notice to property owner and notice to all tenants. I mean, we can probably cover that, but I just think it creates a potential problem. That's all I'm saying.
Okay.
Alderman Savage, and then, Brian, I'll call on you next.
Thank you, Madam Chair. So I want to bring up some of the code I've read from other well, in this case, Rockville. And so what they do is they say, in order to accomplish the required written notification, the following must be done, and they list 3 different things. The first one is, A, the mailing or delivery list for such notice must be compiled from the current tax assessment listing all properties located within, they have 500 feet, within the boundaries of the subject property.
We do that.
So that's one. B is deliver the notice by hand delivery or first-class mail to each owner at the mailing address on the current tax assessment list, and also to the resident at the property location address, if addresses are different on the tax roll. And then C is mail notice by first-class mail to civic associations and homeowners associations within 500 feet of the boundaries of the subject property. So essentially they cover the delivery, mailing or delivery of the list. They mention hand delivery or first-class mail, so it kind of gives some different options.
It doesn't say notice to tenants. That-
Right, but it
I
does,
think-
so,
I think that's the,
but wouldn't they be listed as on the tax assessment list if they own the
not a
property?
tenant, no, I mean, the tax assessment list, that's
But-
exactly
but they
what we do.
But they do say hand delivered to each owner on the mailing address.
Or certified, or first-class mail, right?
Yeah.
It's a either or, so I think it's unusual. I don't think you're gonna find too many jurisdictions requiring notices to tenants, because you can't ascertain them.
Well, again, I think a requirement for a hand delivery would fulfill that.
But that doesn't require you, that's a either or, it's either first-class mail or hand delivery, right?
Well, what does it mean to hand deliver it? I mean, do you have to put it in the hand of the tenant? Or if you deliver it to the address, is that sufficient?
Yeah.
And
it's just
suppose it doesn't
mailbox.
get to the tenant, then,
That's,
And that is the issue. I mean,
Right.
From the commercial end, and Brian could probably speak to this, it goes to the property owner who owns the but does he give it to every one of his tenants? I mean, take a shopping center for example. Is the property owner going to notify, it can go to all those addresses, but that doesn't mean it's going to, all of those notices are gonna go to the property owner, not necessarily every one of the tenants, because all the mail goes through that one funnel of sorts, correct?
Exactly right.
but we have
We
redundancies.
have multiple tenants, and all of that mail came to us as the property owner. So essentially, it was addressed to Northeast Holdings, and then had all the addresses of all of the tenants on there. So essentially, it's just going to the property owner anyway. So why not just send one? Because the way I was looking at it is, why am I receiving 12 of these and then I have to disperse them anyway. I might as well put one on the copy machine, run it 12 times, and then go send it off to each one of my tenants.
See, I can't help but feel this is somewhat of a red herring. How would we know you did that? I mean,
Right,
if
you
this
know.
is a worry.
Well, that's what I'm saying.
That
Yeah, like,
somebody's not
I could
getting
just-
this stuff, I'm pretty comfortable with the way it is. If it turns out to be a problem, then we can address it. But we know the address of the property, and we know the address of the owner. Send it to both addresses, and, you know, we'll see if something terrible happens, but I can't see it. I asked the assistant city attorney, have we had a lot of problems with this? Have we had people coming out of the woodwork? Have we had tenants coming out of the woodwork? Or owners saying, you let the tenant know, but you didn't let me know? I guess I'm not convinced.
You know, I
I
hate to
agree.
dwell on it, and I kind of agree that if the way to overcome any concerns is to send the notice to the property owner, as whoever is listed under SDAT, and then send a notice to tenant, generically, tenant, at the same street address, and that probably is good enough. But, you know, it's just one more thing that we have to overcome, because, you know, these are redundant kinds of notifications. We send notice, we post a sign, we're running an ad in the paper. So I'm just pointing it out that it's unusual to require notice to tenants. But if you want to leave it in there, and we'll give it a try, and we'll just put notices to generically to tenants, we'll see what happens, that's all. I just, it's not the most efficient thing in my opinion, but there's worse things to worry about.
If that's the worst problem this has.
We're in pretty
we're
good shape,
golden.
yes, that's very true.
Brian?
I'm not experienced as Mr. Hyatt here in, you know, obviously land use or development, but I can tell you the first time trying to rebuild a building that's dilapidated and the unreasonable things that come from people who are nearby, I was concerned about this. And I was looking for direction from planning and zoning, and I couldn't get any. How do I know I'm notifying all the tenants? Because there are unreasonable people who will attack you for not notifying tenants. And then you go through the process again, and you say, well, yeah, well, maybe not, this might not happen. But for somebody that went through a Board of Appeals process where the chairman made a call not to allow public input, and then it gets overturned by a new chairman, that's actually the Board of Appeals. That's happening at that level. And that would have never happened before, but this just, to me, I wouldn't want to be subject to not notifying a tenant.
So we will put in a section that no unreasonable people are allowed in.
Yeah, I think that's a great idea. I think
Mr.
it's a
And I
great
think
idea.
there needs to be very severe penalties.
Wow, there
Based,
should be.
Mr. Elson.
based on what Alderman Arnett said and what Mr. Hyatt said, you know, it seems to me that, you know, I personally, since I, you know, do a lot of the boards and commissions, staffing, that I would be satisfied simply with, you know, the typical notice to the property owner, which they do anyway. And, you know, you consult the SDAT, the tax assessment records, you get the identification of the owner, and it's either on site or there's a mailing address listed. When there's a mailing address listed, you can pretty much be sure that it's either a vacant building or there's tenants in there, and it's most likely tenants. And then just, you know, mail to the building when there's an absentee owner, the notice. And then just, we always get an affidavit of mailing from the developer, whoever the developer is, prepares an affidavit of mailing, say, here's what I did in accordance with the city code. I mailed a copy of, you know, the notice to all property owners, and in the case of, and in cases where the property owner's mailing address is indicated on the tax assessment records, I also mailed a copy to tenants at the building without specifying the name of a tenant, which we can't do, because I think everybody here agrees that that would be an incredibly burdensome thing to figure out the name of the tenant. And that's it. And
Right,
then just,
so I would submit that's exactly what 1B says.
that's what I was saying.
You give
Both-
notice to the owners and the tenants.
Oh,
of the
We
property
we can-
located within 200
Right,
feet.
let's
Well, we
leave-
could clarify that.
No, let's leave it alone.
Yeah, right.
You clarify, and then we're off on the lot. I think procedurally, if we can agree that we're gonna send notices to the addresses of the properties within 200
Yeah.
feet, and one notice is gonna be to the tenant, and one notice is gonna be to the property owner, that's all we can do.
Okay.
Yeah.
And just let it go. And
And
then
the
if
list
somebody
is-
complains later, then we'll
And-
just deal with it.
Frankly,
And
I
the list
just
is
can't
supplied by the city.
imagine
No.
Wait,
the appeals board or a circuit court seeing that as anything other than the only reasonable thing that can be expected.
Right, I would agree
Right.
with that.
so, go ahead, Brian.
But Ross did say that the list was to be provided by the city.
No, he's not, the
But
only
that's
list
for
being provided by the
That's for
city.
outside the 200 feet. That's the,
Oh,
going to
okay.
the civic and business and
Right.
condominiums
Okay.
and all
Yep.
of those.
Mr. Gutwald?
Thank you.
Can you indicate in your notes so that there's a record of this discussion for future reference, so we don't,
I told you not to
Yeah,
include
right.
tenants.
No, I want that on a yellow tablet, not a white tablet.
I mean,
Brian,
we-
was that your, last comment? Did you have something else? Okay.
I mean, we could let the Board of Appeals and the Planning Commission know, I mean, I would say that those are the two administrative agencies that would be impacted by this, and we certainly can let them know what's going on here, and that, you know, there would be no, you know, what this actually means, what tenants actually means, which we'll do,
Okay.
yeah.
So there are a lot of other changes in the Second Amendment, and have we already agreed on all of those changes under C, D, E, F?
I have.
Well, right now, it's those three guys who have to
Yeah.
come to the agreement, I think.
I think you.
We have
I thi-
approved
I think
those.
everybody is in agreement with that,
Good.
Okay.
right?
No, wait a minute. This is the confusing part. At the last meeting, didn't you have problems with F? Ross, you brought up that it was confusing and it
F,
wasn't written
F,
correctly.
F,
Page 4.
page 4, F.
I'm
Page-
just
is it really page
recalling that there was a bunch of other thoughts and
I
ideas.
think I did,
5 business,
You-
it's
Rob
within
brought it
5
up then.
business days following the
within the
applicant's
5
written
days,
request.
yeah.
All
All
persons other
persons.
than who have provided written comments to the department, it's confusing, because
Well, yeah, I think I raised an objection just because of, I didn't like imposing that kind of deadline on staff, but
But I think Pete said that he could deal with that, isn't that right, Pete?
yeah, I wasn't worried
Yeah.
about the 5 days. It was, the confusion part is
It was
that,
bad grammar, is what it, I mean, it was.
Right, and
I think
what
the
did it
sentence
apply?
had to be reversed.
because community input meetings, city staff is not in attendance. So we wouldn't know about other meetings and community meetings that had occurred if we weren't part of it. So how would we be able to provide those lists to the business, to the developers? I think that was the confusion part
I
of how
think,
it's
I
written.
think Sheila corrected this by just simply reversing the sentence. Within 5 business days following the applicant's written request for such list, all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application, I don't know this which list of persons, I think you can drop that,
Shall be provided.
provided. You just drop that which list. I thought, Gary, you were gonna get that. Let's see if it went into the final.
Takia, do you have that
We did talk about,
language? Or do you have it written?
I'm
Sorry, I
trying
didn't
to
know
see if
about
it
that
got
one.
into
I
the.
missed that one.
God, I can't figure out where we are.
It's still page 4.
Well, but I'm
It's
trying to
letter
figure
F.
out in the cleaned up version where this got. Oh, the applicant shall.
See, that's the problem with the cleaned up version, because it's incorporated, so everything's shifted.
yeah.
So it's, 1,
What is this referring to? It's referring to,
somewhere around, it says page 6, lines 26 through, or try page 7, 1 through 14. That's probably where it is. But Pete, just rewording that would,
I think that's what it was.
Clarify
Yeah, I
the-
thought we would get something, but I don't think we ever got anything rewriting that, so.
no, but that's his, what I think was the consensus was, is just move the last clause to the front of the front
He
of
has to
paragraph
drop
B.
that one expression.
Mm-hmm.
Yeah, and
Within
then,
5 business days following the applicant's written request for the list, all persons
yeah,
other than staff who have provided written comments to planning and zoning regarding the application shall be provided.
Can't remember. Okay. I'm just bringing that back up because I remember.
Yeah, thank
Yeah.
you for doing that. I
That's-
can't find where it is in the actual legislation, the ordinance itself. I can't figure out where all this stuff is showing up. It says the applicant shall, it's one of who knows what,
It's written under notification, is it
Page-
subtopic?
page 6.
There it is,
Okay,
right
the
there.
applicant,
Next page.
right, so,
It's F, old F.
old F. Yeah, so all persons other than city staff. So that is B. Yeah, okay, so it does need to be, and do we create, yeah, so we need to have a motion to fix, it's basically the wording of that section F.
Okay, so your motion is that, old letter F will be,
Comma, so it's,
reworded so that, the sentence will read,
all right, so specifically, it's section 2110, 020, B1, F. And it should read, within 5 business days following the applicant's written request for such list, all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application shall be provided, shall,
To the
oh
applicant.
God. Who wrote this?
all persons who have provided written comments to the planning of
Gary.
and zoning regarding the application
This is actually in there.
shall be provided, it,
What are we providing them?
it should be a list, it's an all persons, it should be a list within 5 business days, et
See, that's the
cetera.
problem, it's not a list,
A
it's the
list shall be
comments.
provided of all persons.
Is it a list or
who
is it a
have-
posting?
A list of the persons, right?
no, we
Who
don't
have
need,
provided written comment.
we don't need, the words for such list. What it would read is, if you go back up to the top, to 2, it just says the applicant shall also send written notification to. And then B would be within 5 business days following the applicant's written request to all persons who have spoken, et cetera. So, that's the way that would read. I don't think Pete said, it's just comments, it's not a list of people. So we can take out for such list, but
Right,
otherwise,
so-
we're just moving the last phrase up to the beginning.
So the most important person here is Takia.
Right, that's
So
what I was.
Takia, do you have the sense of this? I think it should read, within 5 business days following the applicant's written request, all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application shall be provided a list.
Look at the language, though.
No, I have it up, but I'm just saying, he's changing it, so
So,
that way he can remember what he's saying.
persons who have
Within
spoken-
5 business days, comma, all persons who have provided written comments to the planning and zoning regarding the application, comma, shall be provided
What is it a list of?
the list. It should be a list of all the persons who have written comments, right?
So, therein
list-
lies, think what we talked about, why this got wrapped. We will not necessarily know contact information. We will not have contact information regarding anybody that provided us comments. Comments could be dropped off at, at the department regarding a project or an application. I wouldn't have contacts. I think what this is getting at is that we would provide all the comments to the applicant, not a list of the people. But this is under the notification piece, so it's if they provided us comment and provided us their contact information, we would provide that, so they would be notified about any application that was submitted. Does that make
So-
sense?
So within 5 business days, all written comments shall be provided to the applicant.
Yeah, the question is, who's getting what?
Well,
Well,
okay,
what it
by the
is,
planning
I think what it's
department.
getting at, 'cause this is old language, this is actually in the current, before 035.
I
So,
know.
and you're pointing out something
Right,
wrong with
I
it right now.
know.
Is that if somebody made comment and they provided us an email or contact information or a mailing address, the applicant will be required to let them know that they had formally submitted an application to the Board of Appeals, to the Planning Commission. They would be required, in addition to the people that were 200, they would also be required to notify these people who had provided comments and contact information. This doesn't get to the contact information, so as Gary and I were just talking, that if, to the extent possible, if they provided the contact information, we would give that information, so they would let them know that a formal application has been submitted.
So if someone submits a written comment and they simply sign their name.
Right.
And there's no contact information.
Right. We don't go searching.
We don't go searching for them because if we have 20 speakers and 5 of them didn't provide contact information, we could spend a lot of time trying to figure that out. So it's to the extent that we can identify them, which means to the extent that they gave us contact information, then we know who they are. But to ask us to go looking for them when they didn't give us the contact information in the first place is, talk about burdensome. That could be burdensome.
Can't we just change this to F reads, a list will be sent to Jim Conlon?
You know you're on the mic, right?
So basically, we're just giving, the applicant will send written notification to, when you go down to the paragraph that we're talking about, assuming they request it, the identification of the persons who spoke, then they'll give notification to those persons, provided that they gave us good identification or
Right.
good contact information, which they many times don't.
So when possible,
When identifiable,
yeah.
I mean, I don't want to change too much because we're on the verge of trying to get this thing done, but we could add, if everybody agrees, all identifiable persons, something like that, to make it clear that.
It's unintelligible because we have the applicant within 5 business days following the applicant's request. I mean, it seems to me like we need to know who's requesting and who's receiving. And I'm not clear, and I agree with you, Gary, and Pete, this is old language.
Yeah.
It'd be nice to fix it, but it isn't part of this exercise. We're supposed to be making repairs to 03517. But I cannot figure out who is getting what from this F.
Okay, let me try it. Within 5 business days, the applicant may request or shall request a list of all who have provided written comments to the Department of Planning and Zoning. Is that covered?
Basically, anytime you see such, get rid of that. Within 5 business days following the applicant's written request
Comma.
for a list.
Well, see, that's what I changed. Within 5 business days, the applicant shall request a list.
Within 5 business days of what? When you start, it's the department that is responding within 5 business days, right?
Yes.
So I don't think you can start it off quite like that.
Yeah,
Right.
so within 5 business days, the department shall provide the applicant with a list of all of those who have provided
It's
a
gotta be
comment.
within 5 business days of a request, right?
But who makes the request? The
applicant.
applicant makes the request,
To
right?
the Department of Planning and Zoning.
Okay.
And then the Department of Planning and Zoning provides the applicant with those, the names and contact information of those who spoke. Is that
So the
the way you
department
read
has
it?
5 days to provide the list of those who have
Yes.
commented.
And that's what we talked about last time. Was that enough time?
Right, Yeah,
For-
I mean, cause what we do right now is just upload all the comments into Track It anyway, so they can grab it off Track It, all the comments, and who sent them.
So is this necessary? If it's available now?
Well, it's in current code.
It's in the current, we have to do it now, that's how we're doing it right now, cause, yeah, I mean,
Yeah.
Ross
But the
just pointed out,
change-
it doesn't make
So
any.
it's a mess in current code, it was a mess even before 03517.
Right.
Somehow, everybody's been figuring out how to make it work, but
But we're
It would
adding,
be
aren't we?
nice.
But the
The
chair-
new language is 5 days.
Right,
But
the
the
new
chair's,
days, the new language.
but the
fine.
chair's question, I think, is important though, like,
language.
is this even needed if it's on Track It then?
You-
'Cause the,
now my memory's thinking, I think you guys struck it completely last time.
Because
Deleted
the
whole-
new part is the 5 business days.
Right,
So do we need to put that timeline in there?
no, because
No,
it's
'cause
done, I
that's-
mean,
Okay,
That's available, cause the developers can access,
Right.
applicants can access Track It. Yeah.
right, so do we need it?
and that's why 5 days didn't bother me, because we do it as we receive them, I mean, for the most part. There are, planners do it a little different each of the planners do it a little differently, but as we receive them, we just upload them.
Mhm.
So we can simply say, that the applicant shall send written notification to all persons who have spoken or provided written comments, period.
Right,
Yeah, but they have to be ascertainable. I mean,
But are they ascertainable and Track It?
well, you gotta, I mean, because how would we know otherwise? I mean,
Well,
But
I mean.
they
but-
automatically go into Track It.
Mr. Elson did mention though, inserting the word identifiable. I
well, if
think
you
that
want to
seems
put that
fine.
kind of language in there, yeah.
Identifiable.
Either ascertainable,
Okay.
identifiable, something,
Yeah.
because otherwise, how would we know?
so instead of amending it within 5 business days, we can take that out completely and insert,
We can simply say, all identifiable persons who have spoken or provided written comments at a community meeting, public meeting, or public hearing that has occurred regarding the application. Period.
Yeah.
Does that,
is that,
I guess, it's, we started messing around with things like this, I don't know, I mean,
well, we're
The-
changing that whole paragraph now, or that whole F, all of F, right?
E,
I mean, there has to be a record of these people, right? There has to be some kind of way to find out who they are and their address.
Right.
who they are and if they provided an address.
Yeah.
We can't expect you to provide notice to people who have not given contact information, which is the way it is anyway right now.
Okay.
So how is it ascertainable? I guess that's what you're concerned about,
Mhm.
Alan. And,
There has to be a record somewhere, right?
well, that's why we use the word identifiable, because we assume that it would be in a record. In other words, the only way to identify
Right.
these
Yeah.
persons would be pursuant to some type of record, whether it's Track It,
Right,
or a sign-in,
identifiable in
sign-in
a
sheet.
record of a proceeding or something like that.
Yes.
Yeah.
yes.
well, if they've entered their address on their testimony.
Right,
If they
if they
haven't, it's
didn't.
not your
Right.
responsibility to.
Right.
But are we looking just for their contact information or the actual comments? Pete, I thought I heard you say their actual comments were downloaded into Track It.
They are. Yep. The comments, I mean, the email, let's just take, if it's emailed, we print off the email, we scan it and upload it into Track It. If it's written, we, again, scan it and upload it into Track It. If it's at a testimony, all we do is have the sign-in sheet. We don't, if it's verbal testimony, we don't have record of what they said, unless it was a planning commission or something like that. But, if it's just a community meeting, we wouldn't have record of what they said, but we'd have a sign-in sheet, for
Mhm.
instance. And yeah, at a meeting like that, most people do not give their contact information, just FYI.
Okay, so what is the remedy, gentlemen?
Throw out 1418. I mean, this is so completely different from what is in the code right now, and yet it's not underlined even. I mean, it's not shown as being changed to the current code. So if you go to the current code, 2110-020, section B, notice to abutting property owners, and then you start getting into one, there's no A, B, C, D, or E, and we haven't underlined all of this.
Well, it will be when we get it to Jacqueline Lee.
Well, I thought the whole, I mean, first of all, God, Sheila, how are you ever gonna explain this to the rest of the
I'm not.
council? I know, I agree, I don't see how you can. But seriously, this is very different from what's in the code now.
Well, that's because,
and
I
it's
think that's
not
because we've
showing
added community
that it's a
meetings.
change to the code.
Well,
mean-
it shouldn't be different from what's in the code, isn't and I'm pulling up the legislation now, because that's what you started with. Where in the legislation that is being amended does this,
So, if you pull up the code,
O1418 is a new ordinance, these amendments are modifying
I-
O1418.
I agree, Alan, but all of this stuff should be underlined, showing it's a change from the existing code. That's the shorthand that the council uses. We have strikeout and underline. Strikeout means it's going out of the code, and underline means it's in the code. And none of this, so the way the code reads right now, if you go to B, the first paragraph, B, where up to the semicolon, is as what is in the code. One, the applicant shall send written notification to, everything after that is a change, because we've added a colon, and then all of these sub A, B, C's, D's, and so forth.
well, let me back up a moment. Is all of, oh, please, Pete, come. Is all of O1418 new?
17?
Here's what's online.
So was this all changed with 3517? Oh, Christ.
Ross,
All right.
you can, bring up on
Pull
your
that
iPad.
out. Our city attorney is using this to run our meetings, and it's not even up to date.
Are you looking at the list of amendments on
I'm just looking at the
Granicus?
current code. That's what I thought, Ross, that O35 changed what's in there, and that's why
Right.
this is.
All right. Well, I happen to have 035 handy here somewhere.
So that means that what is in the written code is not the most recent language because of,
That book is not the most recent,
Right.
that adopted less than a year ago, yeah.
and so,
That is in the current code under O35. So it was, yes, it's not a change, what currently is in the code, Ross, so that's.
Right. Okay.
That was from O35, 17.
okay, so the only thing that we were trying to remedy, from what I can gather, is adding 5 days in here.
That's what it, yes, right. But Ross, that doesn't make any sense.
It doesn't.
Trying to
Yeah.
correct something.
It doesn't make sense without even trying to amend the 5 days in.
So you're saying what's in the,
May I suggest, and Mr. Elson, you should take this back, that Mr. Melnick not use that book, but he should use what's online,
which
because it's not accurate. Alan, you either. Yes.
Yeah,
Old school.
when it comes to this section of the code, yeah, I mean, because of what we've gone through with O3517 and now O1418, the current code is not going to be
Up to
the
date.
source to consult at this point. I think O3517 was incorporated into the code, though, after it passed last October.
it was,
Yeah.
it's listed online on,
Not in that.
Right, it's not in the book, but it's in
Right.
the
Now I'm frozen.
electronic version.
yeah.
All right,
We'll,
well,
we'll talk,
my iPad is it's frozen. So, what's the decision? Do we need letter F? Do we need the 5 days? Do we need to rewrite the language so that it is clarified?
good.
And Mr. Elson and I tried to come up with a new version of F. The idea is that when there are written comments, or when there's comments made at public meetings, by individuals who are ascertainable, then they would get notice. And we just have to come up with the right language.
Well,
Someone come up
but
with-
is the language that we talked about all identifiable, or we could use ascertainable? Persons who have spoken or provided written comments at a community meeting, public meeting, or public hearing that has occurred regarding the application, period.
But I mean, shouldn't there be a written record of them or something like that? Maybe you could say they're
If you throw it on the floor?
I'd rather come up with
Okay.
I'm still confused about,
That would be great if you're, like to do that. Pete says, please, not
Yeah,
one more
because Gary,
time.
what you just read, or Pete, isn't a complete sentence.
Yeah.
No, but you gotta,
We did that a month
but,
ago, Ross,
no, but you gotta look at the time, you know, what it says in the case of projects subject to 2110-010B, community meeting, the applicant shall also send written notification to, and then you go down to the second paragraph there, all identifiable persons who have spoken, et cetera. So it's a complete sentence when you read
Right.
the introductory.
But it doesn't make any sense. Because the latter part of that, which list of persons,
Well, we would take that out.
okay,
We would take that out,
Let us try to come up with a
yeah.
two-sentence,
yeah.
circulate it and see if we can't get it.
Could be one sentence.
well, I'm still a little confused though about, to go back what Alderman Arnett, I think, said earlier, is like the intention here today. I mean, what were the main issues brought up in the lawsuit that we're trying to address? Is this,
No, notice
is this
was
one of them?
Notice was one.
And so the problem is what, too much ambiguity?
Right, it was too vague in several areas, but this is new stuff here. I mean, now we're trying to clean up something else.
So you're saying before, I'm trying to find the previous code, what the language was,
Well, I have it here. Let's see if I have more
but
than
Alderman
one copy.
Arnett's right, the letters don't even match up, so it's tough to.
Right.
Because this isn't current.
No, I know, but I'm trying to see what it was before to get an idea of
Well,
what
here's-
the problem is we're trying to address.
All right.
Was it mentioned before in terms of a requirement to notify people who, because
Yeah,
presumably
you're
before there
really
wasn't
making a very good
problem.
point, because the way it was, well, I don't know, when it's in capital letters, what does that mean to us? As
Caps, did you
opposed-
say?
Yeah, so if it's in all caps.
Caps is
That's
an
a change.
addition, is amended language to
New
be.
language, yeah.
New language, yeah.
Well, what's in all caps? I'm not seeing anything in all caps.
Nope.
Well, that's what got passed.
Oh, okay, you're talking-
He's looking at
Okay.
035, yeah.
So,
I thought the remedy here that was being addressed was the timeline. Now we're trying to fix the language of the,
Well,
of
we
letter
would
F
like
In
here.
in the litigation, there were two, and Alan can correct me if I'm wrong, but there were two claims, I guess you could say, that were raised. One was whether the city council on 03517 should have had a second public hearing. So whether that can, and the second one was whether whether the notice requirements were ambiguous or not, or void for vagueness, as the term goes, the constitutionally, the language that would be used in a constitutional claim that a statute is void because it's too vague. So what we're trying to correct here and limit it to the issues in the litigation are simply trying to clarify the notice requirements regarding community meetings so that it can pass the test of sufficient clarity to avoid void for vagueness. So that's the whole idea here, is to address the issue that was raised in litigation regarding, notice requirements. Mr. Hyatt, Alan here raised that issue, and that's what we're here to do right now, to try to make it clear. I'm not sure we've accomplished that, and we may not have, but
Well, 'cause
but that's what the goal was here to.
it looks like, looking at the old code, it actually already says things in there that the new one doesn't. So it says, Oh, that's for notice of decision. Never mind. But it does state like, let's see, notice of decision must be given to the applicant, blah, 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 any other persons who have submitted written comments or testified. But it says, provided they included their legal name and valid mailing address or valid email address.
That's the notice of decision. This is about any meeting that occurred.
I'm
Right.
just kind of puzzled we're not using the same standard, but,
Yeah.
Right, so it's under B.
I still can't even find the written.
The abutting property owners, and one are the things that the applicant must send written notification to. And A is all parties with a financial, B is property owners and tenants within 200 feet, C is the alderperson representing the ward, D is the president or other person of community associations, E, and this is the applicant must do this, and it just is not comprehensible. All persons, the applicant, I think, must send a list of all persons who have spoken or provided written comments at the community meeting. So this isn't comments to planning and zoning. Public meeting or public hearing that has occurred regarding the application. And then what was added, underlined in capitals, is which list of persons, with the exception of the speakers at the applicant-led community meeting, shall be provided by the Department of Planning and Zoning to the applicant.
Which letter are you on?
But we're
I'm
going, with the proposal is to eliminate that language right
It's-
now.
It's underlined.
I know, but the
it's not
proposal
strict-
right now is to strike that from this paragraph and simply limit it to all identifiable, or if we want to use the term, ascertainable persons who have spoken or provided written comments at a community meeting, or public hearing that has occurred regarding the application, period.
Okay, so, Brian, this is what Tony Christoph was doing at the meeting last week, because he was getting a name. So the applicant must do several things. One of them was basically a list of all persons who have spoken or provided written comments at a community meeting, public hearing regarding the application, period. So all we have to do is this section E needs to start with a list of all persons who have,
No.
and then get rid of all of that.
So here lies the problem. There's the community, this is what I was trying to do originally, but you guys, that was not the will of the committee, was to separate the community input meeting and all the notification requirements for any application that has received. We combined that back again. I tried to separate it back out.
Right.
So when you're trying to talk about a list, or you're talking about somebody that spoke about it at another meeting, how do you deal with that if I've got written comments on a variance that is submitted to me? It doesn't really jive with some of our other processes, because we have to send this application, this list of people that have provided comments to the applicant when he formally submits his application.
Right.
What if they didn't have any?
Right.
They just submitted it.
But that's under F. And F doesn't belong with the things the applicant should do, because F really means all persons other than city staff who have provided written comments to the Department of Planning and Zoning regarding the application should be provided a list by the Department of Planning and Zoning. So it doesn't even belong in B1, because B1, A through E, are things the applicant has to do.
But wait a minute, F, but
yeah,
F
I
is speaking to, wait a minute, F is speaking to, I think, is speaking to the applicant sending information to all those people who have submitted
Yeah.
written comments.
No, that's an E.
No,
That's F.
No, E is
You're in
where-
the wrong
Look at,
document.
no, I'm not, this
Yeah.
is the city code.
no, that one.
We're in the
I think you need
amendments.
to go off this.
I think I need to go off.
I think one has to do with, community meeting, public hearing, the other has to do with that they just sent in an email to the city staff.
Correct, that's what it is, that's the difference. If they've sent written comments to the Department of Planning and Zoning, then we ask for the names of those people who have sent in the written comments, and they would get notice. That's
And
that's what F is.
That's F.
Yeah, E is the burdens on the applicant because it's from the community meetings, public meetings that they have a record, that the
Right.
applicant has a record of.
So that's what I'm saying too. I'm saying E is the responsibility of the applicant, and I think F is the responsibility of planning and zoning, and therefore shouldn't be under this section. The applicant shall send written notice to :
All
And-
the people who have provided written comment. That's F.
that's E.
No,
That's F.
E is community people. F is anybody who's provided written comment to the planning and zoning department.
But both lists are kept by the Department of Planning and Zoning.
So
Well,
E
no,
is,
wait a minute. Let's go back to what just happened. Do you have Tony Christoph's comments from the meeting on 4/24, 4/28 from last Wednesday?
No, because he doesn't have to submit that within, he's got 30 days to submit the summary of the meeting. That's in another part. Are you talking about his comments that he received, and what was the general?
Right, at the community meeting
Yeah.
that he held.
So what we're talking about in this section is just separate comments provided to the department. The problem is this is again, it's assuming there's a meeting that has occurred. And there may or may not have been a meeting occurred because it didn't meet the qualifications for a community input meeting. Because this whole section is under notice to abutting properties. And what you're saying is that you're not sure it belongs in this section, but that we consolidated the sections that when
well, let me be clear. So E speaks to anybody who comes to a public meeting and makes a comment. And then F is people who provide written comment to the planning department.
correct.
This
And
settles
could they
it.
be one and the same?
They could be.
Could be, but
Could
this
be.
settles it. I'm going to law school because I want to challenge this code and make $400 and some odd dollars an hour.
Well,
I'll
I
tell
mean,
you
it
what,
goes
there's
back
a lot
to
of
your-
potential challenges in that code. I'll be happy to represent you.
It goes back to your kind of concern, Alderman Arnett, about just how are we gonna explain this to our colleagues, and
Yeah.
maybe we just need to start from scratch and just do a complete strike and substitution, striking this section of the code, here's the new code, because then they can read through it and it'll make sense. I don't know if that'd be a better approach or not, but it seems like.
Well, that's what I was trying to,
That's what you were
why I
trying to do
needed
with that,
see
right?
this, because I wanted to see, what the hell is this gonna look like
I
if
know,
we
but
accept
this
it?
doesn't strike and cap. Now, I agree with you. I think ultimately that would have to be part of the legislative process, isn't it? That they have to show you the whole legislation as amended?
Well,
Yes.
yeah, well, that's what,
Well,
Because we never know what we're doing otherwise,
Gonna get-
or what the staff,
But that would
think we
include
were
all
doing.
caps and strikeouts.
it would have to.
So you take 14, 18 and caps, strikeouts, right? Just the new 14, 18.
well,
With, as amended though, including
That's what
the
I'm talking about,
amendments.
yeah.
There were
but what are you amending the O?
14, 18. yeah.
14, 18, that language as it
Well,
put in the code,
I
you're
mean, it
amending?
seems like the simplest thing for all of us to understand what's going on is to take the bill, and that has caps and strikeouts as well, and then put all the amendments in them at caps and strikeouts, and that way you can see what's
Is that
different
what
from
your
the
draft
existing
has?
language,
Amendments?
including
the
And
draft
strikes.
is assuming that we have accepted everything 1, 3, 4, 5 from the Rules Committee, plus the revised 2,
Right.
which we thought we had agreed to, but
Oh, but
But that
document's-
doesn't show
Right.
the changes.
Right.
Everything's incorporated. What we have in our initial document is the legislation with the changes. And what we want to add is a separate category, maybe in red, that show our amendments. Is that what we're?
Yeah, I mean, Alan did that originally, he had red and blue, and he had my amendments, he had his amendments.
We don't have a color copier though. I mean, we do have one, we can't use it.
Right.
I think we can use it, I wouldn't worry about that, but would that make sense if you try to
We
do
have to
it
go to
that
the
way? so
finance
it-
committee to make sure we have the appropriations.
yes, well, hey, Hey, the
We'll
finance
leave
committee
that.
did right by you.
Alright,
Would that make sense to try to do it that way so
I
that
think
it'll
so.
be clear?
Try to circulate a new revised 01418 with caps, strike-throughs,
Yeah,
just to,
and a color to show the amendments.
right, yeah,
We could do that.
okay.
okay.
Yes, sir.
Will that be embedded into the agenda for next week so we can see it there?
Which, you mean the rules committee?
Yeah, for the rules committee, like normally, like I pull all this information off of, I go into the agenda and then it
Yeah.
lists all of the,
Yeah, but it
Yeah,
won't be.
can we
Amendments,
get
et
it,
cetera.
Whenever they're
It'll
when's
be
the
next
next,
month.
yeah, next month.
oh, okay. But I mean,
but yeah,
eventually
we can
that would
attach.
be, that would be put in there as well. Okay, thank you.
We can make a point, Ms. Green, to make sure it's attached before the next meeting. Okay.
Can I add one item?
Mm-hmm.
And we've talked about this before, and I wasn't here at the September meeting. I don't know if it was approved or discussed or how you reached the conclusion, but we still have this business of having a hearing to go to the planning commission when you have a special exception. That's in the, that's on page 8 of 9, if you're looking at that document.
I think
In the
already-
table?
We already voted on that.
In the amendments, the rules committee amendments.
Right.
I
And-
think that's where we have 8 of 9.
Where did that go?
Well, yep, where we
Right here.
had a major site design has to go to the planning commission for a public hearing. But we had at one time language in here that if it involved a special exception, you wouldn't have the double hearing process. And now it's back in with an amendment, which I guess you already voted on in September. And, I'd like you to reconsider it until we come up with a better definition of major site design, because, that's a struggle. And I gave the example where you can have a 20% increase in square footage in a relatively small building. That's major site design. That would take you, and if it's a special exception, it would take you to both the Planning Commission and to the Board of Appeals, and it creates, years ago, the City Council changed the law to avoid going to both Planning Commission and Board of Appeals. Now we're back again, and it's just burdensome. We had a the argument was, well, the Planning Commission will get through the process quickly, but it doesn't happen that way. We had a hearing July 5th. I'm still waiting for the opinion. I was talking to Mr. Waldman the other day. A relatively simple matter, approved July 5th, and we don't have the written opinion yet from the Planning Commission. Mr. Elson was absent that night. and it's a bad process. And I know you've made a decision on it, but you can always reconsider that. And I just plant the seed, and when we submit the amended 01418, I'd like you to consider that, because it really is burdensome.
You're speaking to amendment number 4?
Yes. Yep.
I'm looking at the rationale.
Somehow I've lost all my pieces of paper.
Alderman? Oh. But it's right there.
I know, but I can't. I'm old
Mr.
school.
Elson, you want to respond to that?
Okay, yes, thank you. I understand the burden of going through 2 administrative hearings on one application, which is what we're talking about here, a special exception application that has site design implications. So in other words, special exception would go to the Board of Appeals, site design under the current code now, 3517, would go to the Planning Commission. Before 03517, site design was within, major site design and minor site design was within the control of the director. 03517 took it out of the director's hands and gave it to the Planning Commission. there was no, as I recall, no consideration of the fact that if we have a special exception application with site design, not just a special exception application, which we often get, but a special exception application with site design, then what do we do in that process? Do we go to the Board of Appeals first with the special exception? Do we go to the Planning Commission first with the site design part of the application? So in 035-17, you know, it's the thought at that time was simply, well, major site design will go to the Planning Commission now, and the director will just make a recommendation to the Planning Commission and not make the decision. If we kept it that way, just to go back into history a little bit, if we kept it that way, in other words, if the director was still going to make the decision on a major site design application, then anyone challenging the director would appeal to the Board of Appeals, because directors' decisions get appealed to the Board of Appeals, not the Planning Commission. So that's the way it was. Then with 035-17, we took the site design away from the director. The director would make a recommendation only, and it would go to the Planning Commission, and appeals of and so the director couldn't really be appealed at that point because all he was doing was making a recommendation. So when it would get to the Planning Commission, anyone appealing or aggrieved of the Planning Commission decision would then go to Circuit Court. So that's the way it stood after 035-17, but then the challenge came into 035-17, and so that process is now, for lack of a better term, stayed with the preliminary injunction that the court has entered by consent in the Circuit Court. So now with 014-18, there was originally a provision in there saying that if you have an application for special exception with site design, that it would simply go to, did we say the Planning Commission?
The special exception would go to the Board of Appeals, and site design would remain
Right.
administrative, right?
Would remain administrative, okay. So therefore, that you wouldn't have the two-agency review of one application, because the site design would be returned back to the director, taking it away from the Planning Commission, and then if the director got appealed on a major site design application, it would then be with the Board of Appeals. So there's this thing with the Board of Appeals and the Planning Commission, where does it go to? So the problem with having a special exception application with site design is that you're dealing with two administrative agencies, which is what we have tried to avoid all along. Back in the day, 7, 8 years ago, whenever it was, the site design, a special exception application and a variance for that matter had to go to the Planning Commission for simply a recommendation. Yes, it did.
Let me simplify this.
Yeah.
Okay, sorry.
Chicken and egg.
Wait a minute, I thought Bruce Miller left.
I guess someone can simplify it. Let's go, Pete, see if you can do it.
Chicken and egg thing. You got a project that is a special exception and is also a whatever. Remember, we changed the threshold. It goes to the a major subdivision and a special exception, or vice versa. Chicken and egg thing. Who do you go to first? Right now that you're required to go to both places. If you go to the Board of Appeals because of the use, they have to make a finding that the site design meets the criteria. What if you go to the Board of Appeals, now the Planning Commission changes the site design. They make modifications to the site. Does it have to go back to the Board of Appeals? So, staff is struggling with having to do both applications at the same time. If the Board of Appeals is approving the use and the site design is done administratively, the Board of Appeals, in order to approve the use, have to find that it has met all the site design criteria. That's the crux of all of it. It's a chicken and egg thing.
Right, and that's not what the Board of Appeals does.
What was that?
The Board of Appeals says, is it in the code? Yes, no. No, you're out of here.
But there is...
Was the code followed? Yes, no.
Right.
If it's yes and yes, you're out of here. If it's yes and no, then they make some kind of finding. But they don't get into site design at all.
Correct, but they make sure that it
That's
has
why,
met the
frankly, I think the two bodies do two very different things, and we really made a mistake in trying to force things to go to one or the other. The planning commission looks at site design and community character and all of those things. The Board of Appeals just doesn't want to deal with that. It's just simply, is it in the code, was the code followed?
Well, I have to disagree with that. I mean, the Board of Appeals is a little bit more methodical and analytical than what you're saying. They do look at the surrounding, the character of the surrounding community on variances, and I think on special exceptions too. So they are required to do that, but right now until 03517, we had this distinction between the Board of Appeals and the Planning Commission. The Board of Appeals would get special exceptions and variances, and the Planning Commission would get plan development. And the director had control over site design and could be appealed to the Board of Appeals. That's the way it was, if I stated it simply.
Right, yep.
And now, it's 035 changed that.
So what's the remedy?
Well, what I had suggested as a remedy is that only in the cases of special exceptions would the Planning Commission not hear major site design decisions. That would be the Director of Planning and Zoning. So that way you don't have two deliberative bodies that are potentially in conflict, and you don't have this lengthy process. It just creates a potential mess when you have, and I agree, the Board of Appeals is looking at the use when it comes to a special exception. The Planning Commission is about planning, design, that sort of thing. So the director would step in the shoes of the Planning Commission when there's a special exception. Otherwise, those two bodies don't coordinate very well, and we create potential conflicts and
Well, I mean,
delays.
because I don't think they're intended to coordinate
Can I
very
jump in
well,
on
but.
that?
I wanted Pete to respond, but go ahead.
Well, just a quick point though, because I feel like was this even a subject of the underlying lawsuit? Like, why is this being proposed
Yeah.
anyway?
It was not.
It was not.
I mean, because I was told with some of my other amendments months ago that, oh, let's not consider them. We want to stick to what was subject to a lawsuit. So why are we even bothering trying to change that right now? Let's just not
I
deal
agree with
it.
that. That has been the way we've been trying to guide you, or requesting that you accept our guidance as to, let's just deal with the issues in the litigation, and anything else that's over and above litigation can be, the subject of a different ordinance. I just want to get through the litigation. I think, Alan obviously wants to get through the litigation. We can do that easily by just dealing with the issues in the litigation, and then all these ordinances all the other issues like Alan's raising right now can be dealt with by separate ordinance. That was the reason that I asked the Rules Committee to not consider that, and with Rob and his amendments, and he deferred on that. And so to a different day, it could be, it could be tomorrow, but it would be a different ordinance.
So are you suggesting that what is this, Amendment 4 be withdrawn? Because we made a decision, I think, did we not, on all of these amendments, other than
I
two?
thought we agreed to everything except for two.
Right.
Yeah, no, I'm not
Well, no,
suggesting that we do anything with what's been approved so far, because I think it all had to do, as I recall, with notice requirements.
Well, is Amendment 4 part of the legal,
Where is that?
because I'm hearing that it's not, but we have it before us and we've agreed to it anyway, so,
Well, we didn't entirely agree to it.
well, we voted on them.
We did, but we voted to strike the footnote 2, because
Right.
that's above and beyond the lawsuit.
Well, and also, I don't agree with footnote 2, so I wouldn't want it in the legislation. I mean, somebody else can propose that amendment, but I didn't agree, and I explained why I didn't agree to Pete.
Well, I'm not clear, because I'm not seeing a strike through on amendment, or footnote 2.
Has it.
Yeah.
We didn't get sent this, but this version, I guess, came from our last.
Okay, because it's underlined, but it's not a strike through.
Yeah.
Realize
But
it
the-
wasn't uploaded, but I emailed it to,
yeah.
She just emailed.
I
The-
just emailed.
And what happened to footnote 1?
Just footnote 2 was, by motion of the Rules Committee was stricken. I think
Okay.
1 remains.
Well, yeah, I thought so too, but what this is showing is 1 is gone and 2 is remaining.
Well, 2 is underlined, I don't know what that means, but it's not a
You're not
strike
seeing
through.
that, I know, I know what you're talking, that's what's loaded up in Granicus. There is another version of the set of amendments, and I think Ms. Green is referring to those.
So how about you bring that back to
Yeah,
us?
we can't,
Also.
I don't have it either.
Because, we've got too many different
Okay.
versions of stuff.
but can I go back
But
to
the last
something?
amendment that
Yeah.
we're talking about, with the removal of that eliminated, I mean, it was put in as a proposal of series of amendments that we all worked on, and then you eliminated that last one because of Ross was against it, and Rob brought up the same issue, that it wasn't part of the injunction or the court action,
Yep.
so.
But that did come from you guys as a recommendation to the Rules Committee.
Correct.
Right, but the Rules Committee struck it
Right.
in September, right?
Mm-hmm. Okay.
I mean,
Well,
that's a done deal, I think, right now, as far as the Rules Committee is concerned.
Say
'Cause
that again, I'm
That's
sorry.
a done deal as far as the Rules Committee is concerned. The Rules Committee did strike that footnote.
It just didn't get stricken in Granicus.
I mean, yeah, that's
But
that's,
footnote 1 did.
Well, we're having a
Well,
version
we're not
conflict here.
striking one then.
No.
Yeah, but we'll get a clean copy,
Right.
which will have all of this, because I don't know what 1 is.
Yeah, what we have in that version, there's proposed amendments, and then there's showing amendments to the amendments, and that's the problem.
Mhm.
That amendment should just go away because it's proposed amendments to the amendments.
Well, those are the Rules Committee's amendments to the original legislation, which is the amendments to the code, right?
Yeah, when you finish all this, so
Yeah.
some of this shouldn't even show up because it was amendments to the amendments that you guys were proposing.
Okay, but they didn't pass.
Right.
Yes, okay. Ron?
Well,
Okay.
I can't
Yeah,
help,
it is.
oh.
I'm, Brian?
Well, I'll
What's
let
your
you
last name?
continue
I'm
on,
sorry.
Ross. I'm gonna have a question at the end. I'll have a
is
question
it?
after you finish your.
Toomey. Mr. Toomey, you don't have a question now?
Yeah, so I'm just here as somebody who's trying to, again, go through the process. So I think I got some clarity last week when I spoke with Gary and said, I guess if your application is in, what applies is what was the code prior to 03517? Because I'm trying to figure out what we're supposed to do.
what I said was, I mean, the question, Brian asked the question, they've got an application in right now.
Correct.
Is that right, Brian? And what do you do with this? We're in a state of flux with the review process here on notice. And my answer was 03517 has been stayed by the court. The implementation, administration, and enforcement of 03517 is currently, by preliminary injunction, stayed. We haven't passed 01418, so the only thing that we're left with at this point is to go back to what the law was before 03517. And that's where we are right now.
But I thought also new applications were stayed until we got this sorted out.
New applications by the plaintiffs, I believe, was stayed. Because
So
we
anybody
can't,
else in the city can come in
we
with an
can't, in
application
that
and-
litigation, we don't have jurisdiction over any, the court doesn't have jurisdiction over anyone but the plaintiffs and the defendants. So the court is not in a position to say to the whole world of the city out there, no one's gonna be able to submit new applications. There's just no jurisdiction to do that. We have to deal with what we had, and that is we have plaintiffs and we had a defendant, the city, and the court can only control the conduct and the activities of the parties to that case. And that's why it says, on no new applications by those plaintiffs, in the case which were Solstice and
That's why we gotta get it done.
Prohl, I believe.
Gotta finish this up.
So until,
But does anyone else have an application besides Alan's clients?
Mhm.
I was gonna say,
Course
we have
they
a
do.
number of so herein lies another question I have, so you have 03517, which grandfathered anything that had an application. You have Mr. Toomey, who submitted an application after that, but during this injunction.
Right.
or whatever it's called. So, we passed this legislation, O35 grandfathered him, but O14
Also
is.
grandfather.
Oh, also grandfathers or doesn't grandfather? That's
Yeah.
what Rob was proposing, not the grandfathering.
Right.
So
We
that's
haven't
not
even
on
gotten there yet.
That's not, huh?
We haven't even gotten to that one yet.
Yeah,
Okay.
right. But the bottom line is we're in limbo right now, so the only law that we can revert back
I agree,
to.
but I don't
let
understand
him
how we
finish.
can get a clean version. We keep talking about these things and we go away and we think it's gonna get sorted out, and it doesn't. So we talk about them meeting after meeting after meeting. Brian, I think my sense of the answer for you is you're not being upheld by either 3517 or 1418, but you've also complied de facto with the meeting you had the other night that Tony codified. I think you've complied with the spirit of it.
It was voluntary, and it was
It was
compliance with the
voluntary.
spirit of is intended to be the new law. But it's strictly voluntary on their part. We are dealing right now with what existed prior to 03517. There is no other law that we can look to right now. We haven't passed this legislation, and 03517, that legislation is stayed, and we can't administer it or enforce it or implement it in any way. So we have to revert back to what we had prior to 03517, and that's the answer to Brian's question.
I think it is, and remember the whole impetus for Joe and I was we wanted the community to know about something that's in the offing at the same time the planning department knows about it. I think the community is well aware
Yeah.
of your application, Ryan.
Right, I mean, as you know, Ross, I had an informal meeting before the formal meeting, so.
Right.
But I just wanted to make sure, as far as the process goes, does it go to planning commission? Is it a bifurcated process the way it's listed here, or is it just going to Board of Appeals? Because it's going back to prior to 03517, since the application is in.
Yeah.
That's why I wanted clarity on that.
Well, we don't have an answer to that
Well,
yet.
but I thought Gary said,
Yeah.
since 035 is in a holding pattern, we have to revert back to the original code.
Yeah. if you
And
look
that's
at-
what we have to hold everybody, you hold you accountable
If
for.
you look at the consent order, the first one says the parties hereby consent to a preliminary injunction by which defendants are enjoined from enforcing, administering, and implementing City of Annapolis Ordinance 03517.
Mhm.
And so where are the defendants?
So we're left with nothing but the pre-existing law.
Mhm.
But
that-
the
that is the-
problem,
Excuse
the
me?
problem is, what's in our code, what's listed is 03517, that really should be reverted back so there isn't confusion.
That's correct, Rob, but, excuse me, I think that the planning department obviously knows that they can't enforce 03517 right now, so regardless of whether it's in the code, what was that? Okay, regardless of what's in the code right now, it is not, it's in a holding pattern, what's in the code. Planning department is just gonna have to implement the pre-existing law. I don't recommend that we remove what's in 03517, from the code right now, because 01418, I think we all agree in some form, is gonna be passed. We just don't need to get it right, and then the code will change, based on what's in 01418. So I would rather not take 03517 out of the code, but the planning department needs to let applicants know what's going on.
So how would you even do that? Wouldn't there have to be a legislative action to repeal it?
Right.
Yeah.
And look, let's put it this way. Theoretically, say 01418 does not get passed and we're at an impasse in the litigation, we would have to litigate it.
Right.
And then what if the court were to decide in favor of the city, which I'm not saying is by any means a stretch. I mean, I think that, conceivably the court could decide in favor of the city, then 03517 is the law. So I think that we just leave it where it is in the existing code, and then we move on to pass 01418 in whatever form it winds up to be. Hopefully it'll pass.
The confusing thing is, though, because if you look at the previous code, for example, I'm looking at that table, there's no footnote So then when our colleagues look at the amendments and say, why are you striking a footnote that's not in the legislation? So the amendments are kind of amending 035, but it's confusing because 035 was never
I know, that's, we
made
need
law.
to get a clean set of amendments. The issue is what we did, you had a set of amendments, and then we amended the amendments, and we're showing that as a strike-through or a cap as the amendments to the amendments. We need one set of amendments for you and the
Right.
colleagues, because these set of amendments that you voted on are the amendments. What we did in some of these documents is show you the changes to the amendments, which is confusing.
But
That
so-
strike-through shouldn't even show up.
So now we should have 01418 color-coded, so to speak, with the amendments as this
From the rules
committee has adopted them, and then we need to come up with some language in that one E and F section, and then that
fine.
should be it, right?
I'm good with
And we're
that,
go-
yeah.
Okay. And then things like the Planning Commission, Board of Appeals discussion, that comes later.
Right.
Definition of major site design, later, right? We're gonna try to accomplish all that. Let's get this
But
thing.
not that much later.
Okay, but no, I don't want it that much later.
It would
That
make much
makes
more,
sense?
it would make
So-
much more sense for
Okay.
both issues on site design to be in one ordinance than in 01418.
But
I
that'll
think.
come after 01418. Let's just get this
Right.
thing done so we can
Yeah.
stop meeting like this. Right? I mean, that's-
Mr. Toomey, are you okay now?
So, just to clarify, I would be following the process prior to 03517, okay?
Yes.
Thank you so much.
There's a lot of agony to go through just to get that answer.
Because I asked him, I encouraged him to follow this, because I knew it was coming.
Sure.
I didn't know whether it was gonna be
Yeah,
retroactive
no.
or not, so that's why.
I think Mr. Toomey has done everything that's expected of the code, even though a couple of nearby neighbors don't feel the same way.
So when is the next Rules Committee? Have you set that yet or not?
No, we will set that at the end of this meeting.
Yeah, we're probably
gonna
need to have another one
And that
soon.
needs to come soon.
This
But,
has been a
Mr. Gutwall, are you good on where we are with this?
Oh, I
As
still
far
have an
as
amendment.
035 and your department and how they're conducting business in light of the,
I think
litigation.
so. My only question is this whole I mean, we're not implementing 035. That had a date and time when applications were grandfathered. This will now have another date and which applications are grandfathered, so the tweeners, Mr. Toomey, I guess, is grandfathered. If the grandfathering language stays in 01418, then he's also grandfathered from all of this. Because it's as of the date of the adoption, currently the way it's written.
Well,
So, does he go back to what was written, was it the date of 035, or is it the date of 014? If he was in between? That's my only question.
If I can indicate my position, and that is that we are here telling Brian Toomey that he's under the pre-existing law. Can we say to him, 2 months down the line, 1 month down the line, when 01418 hopefully passes, oh, by the way, you now have to, comply with 01418. We're telling him right now that he is under the pre-existing law. The law is in a state of limbo. And we can't keep a developer or, whether it's a resident developer or a commercial developer in limbo like that. They need to know what law is going to apply to them right now. And we are here saying to him, go ahead and operate under the law that existed prior to 3517. I think it would be very unfair to him to 2 months down the road saying, we just changed the law. That's one thing that we do need to discuss, when that can happen and when that can happen or shouldn't happen. And that's for a separate piece of legislation, hopefully, when we'll have that debate. Because the case law indicates, that when we're talking about retroactivity, that there are times when retroactivity is permissible, and sometimes when it's not. And we need to, in my mind, we need to consider the current case law about retroactivity in zoning legislation, which will come up. I assume Rob is going to introduce at some point, another ordinance dealing with that issue, and it's debatable it's debated at that time, I would think. Eventually the parties will, whoever the interested parties will state their positions.
So I think we can agree as a committee that we will support the statement Gary just made, that Mr. Toomey's in the process. We've told him that the pre-existing code is applicable to him as opposed to the new.
I just.
I think it's only fair that we codify this so that somebody doesn't come back 2 months from now and say, oh, by the way, they changed it again, and now you have to,
Yeah, but
So
that's-
I think
So we can agree
Well, yeah.
orally till the cows come home. I don't think we have the authority to do that.
Well, but we can make a recommendation to our fellow colleagues that this is the position that the Rules Committee is taking.
But it's not gonna be our colleagues that are gonna give Brian problems. It's gonna be somebody from the community that is gonna go to court. And I don't think we can, I mean, we're in the same muddle as Brian.
Well, I think that the Rules Committee may not be able to, say yes or no about how Brian is supposed to proceed, but the law office can state an opinion as to what we think is the applicable law, and that's what we would have to do if it came to that. So I think,
Yeah.
Ross, you're right. I think the Rules Committee should not get involved in that. It's up to the law office and the planning department and the developer to work it out in the right way, at least at this point.
Mhm.
My recommendation as a member of the law office would just be that we have to give him the knowledge that he needs to have right now to know how to go forward. And what I've said here today is, it's subject to the city attorney overruling me, which I don't think he would do, because we've already discussed this,
Right.
is that the law office would say, Brian Toomey, on his application, proceeds under the law that existed prior to 03517 because of the status of litigation and the undetermined status of 01418.
But I don't think that's, I have an amendment to
Right.
address this. I do want to propose to have, I don't know what Mr. Toomey's project is, where he is in the process. I have no idea. But what I was trying to propose is setting the standard of any projects that don't have approved final plats shall comply with the new regulation. And I know you sent some case law, and I'd argue it actually supports the retroactivity I'm proposing.
I have to disagree with you because I've read that case numerous times at this point.
Which one do you?
The one on retroactivity and zoning legislation.
I mean, because looking at the one you sent out, the McHale, it even says in there that if there's a demonstrative, the court may construe a statute as applying retrospectively or retroactively that affects a non-vested right if there is a demonstrated legislative intent to that end. And that's essentially what I'm trying to do, is establish the...
Right.
It goes on to say that there's a general presumption in favor of retroactivity in zoning and land use cases.
It's just a
Because again,
presumption.
we've had some projects that are in the pipeline for, like Chesapeake
Right.
Grove. That's been in the pipeline for almost over a decade now. Where do you draw a line? It's tough. I know it's kind of a larger issue, but as a legislator, we're elected to enact new law. So if our hands are tied, I get it to balance with the applicants, but I think we need to be able to pass law that takes effect.
Yeah, I think the case law says more than you're saying right now, and I am prepared to review that with the Rules Committee or any other committee at the time that legislation would be introduced for retroactive purposes. If it's going to be an 01418, my position is still be that it shouldn't be an 01418. It should be in a separate piece of legislation that's not associated with the litigation. And then, I'm more than happy to address what I construe as the case law regarding zoning retroactivity, zoning legislation retroactivity. I think it says more than Rob is saying. It says he's reading part of it, but not the whole thing.
It does, but it even goes on to say, in land use and zoning cases, the general presumption is that in the absence of a contrary legislative intent, a substantive change to the law occurring during the pendency of land use litigation and before any substantive rights vest is to be applied to the pending legislative matter, understood therefore to be upheld retrospectively to some extent. Yorkdale, however, recognized the primacy of the legislature's intent when determining whether a change to the law applies prospectively or retrospectively. So, I mean, I could go on, but there are tons of case law that supports it. I mean, I brought this up at the last Rules of Government meeting, and, you know, with the hopes of having this discussion. I mean, that's...
Is your intent to try to amend 014?
Yeah, that's what my amendment is. That's what I'm proposing to do. Amend on page 9, line 4, insert the language I'm proposing, which is the standard of if projects don't have approved final plats, then they have to comply with the new regulations.
I still think that is, it's a difference of opinion in construing this case. I don't think you're touching on all of the language in the opinion that is there about when to apply retroactivity and when not to. But if you're going to introduce it in this litigation, legislation, I certainly am not in a position to stop you. I can't stop you, obviously, and I wouldn't even, you know, I certainly don't think that I would ever have some authority like that. But my opinion is that, you know, again, we keep the issues in 014-18 confined to what's in the litigation. Get through the litigation. We've had a preliminary injunction since, I believe, March. Was it March? February. Here we are in October, and we're still trying to get this thing done. And, you know, the more issues that we put in this, the longer it's going to take to get through the litigation. It's just as easy to put it into separate legislation and debate the issue of retroactivity there. But I'm more than happy. I can even, you know, write up a memorandum, an opinion to the board, to the...
Well, I just don't think, I don't think doing this after the fact would be helpful, because I think, again, reading not just that case law, but many others, we have to establish our legislative intent. And that's what I'm trying to do. But even if you don't, from my readings, is even if you don't establish intent, the courts tend to side on retroactivity in terms of land use cases, which is what this is.
But you're saying they tend to decide, and there's a presumption, but the presumption can be rebutted according to the case law. So you can't just say we can do it. You have to take into consider due process. You have to take into consider equal protection, which are constitutional issues. You have to take into consideration also what the court said, that if a person has acquired a substantial interest, that's not vested, but a substantial interest short of vesting, that has to be taken into consideration too. And I know your position has been Maryland is a vesting state, but not when it comes to, you know, retroactivity. It's a different issue. Vesting.
Late vesting.
Excuse me?
Late vesting. It's a late vesting state, not so.
Okay, all right. So, but I'm just saying that other issues besides vesting, according to this case, need to be considered by a legislature in deciding whether to apply a statute or an ordinance retroactively. And the other, you know, the court says, yeah, establishing legislative intent is important, but the intent has to be consistent with what the law requires. You can't just say, we intend to do this without considering the law. You know, plenty of legislatures say, you know, this is what we want, that's legislative intent, and then it's subsequently overturned by a court as being unconstitutional. So legislative intent is important, of course, but it's not the be-all and end-all.
Is this the subject of the legislation, retroactivity?
Well, Rob wants to introduce...
Well, but we just had a
amendment.
discussion about what was not part of the legal stay that we're in now.
Well, in 035-17, there was grandfathering. 035-17 has a grandfathering provision. And didn't this body adopt a amendment already for grandfathering, or no? Didn't you adopt amendment number 5? Or not? Page 9 of 9, you know that thing we were looking at?
We did adopt.
Yeah, we
I
did.
th- I think you already adopted it. So, you know, Alderman
But-
Savage, I think it's a problem. In this particular legislation, it's a real problem to not have grandfathering, because what do you do? If applications are already filed, how do you go have a community meeting pre-filing? It just doesn't make any sense. This is one where, you know, we can debate retroactivity and all that sort of stuff, but this is why grandfathering was approved with O-3517. This committee approved it. I don't think it's, I think if you really consider this type of legislation, it needs to have grandfathering. I don't know how you'd function without it. It creates a big problem. Think about it, okay?
Well,
For the record,
I do think that it's a worthy issue, but I would have to say, for myself personally, back at O-3517, Alderman Budge and I made a commitment to that grandfathering, and I feel honor bound to adhere to that. I think we really do need to be looking at all the grandfathering that goes on, because I do believe when you make new legislation, that's the way you want things to go. And if you're in the pipeline, that's one of the bad breaks of life, but that's not for this legislation. And I do think that I am in a personal position of having made a commitment about the grandfathering that I don't feel I can back away from at this point. I mean, I don't want to back away from it. So,
okay.
a commitment as to, in which direction are we talking about here? Grandfathering
you're screwed.
meaning. I know, I know. I mean, for the record, seriously, I'm a business owner in the city, not a developer. I'm trying to move one of my businesses into a piece of property that I own, and I feel like I'm getting caught up in all this. And my intent is to follow the law, but what's happening is there's going to be a lot of jobs lost because this is dragging on and on and on. And then if there's some grandfathering in that I have to go back and do something a different way, it's just going to delay things. So, you know, it's a hardship for my employees who have families, and, you know, I provide health insurance for. And, you know, they've worked for me for 20 plus years, and what do they do in the meantime while all of this is going on? Well, we're stuck in the process here.
Well, and we don't want it to drag on and on. I'm just looking at the next date for the Rules Committee.
We need to do something sooner than
I was
that.
going to suggest that maybe, could you see if there's another date prior to, the next meeting is scheduled for the 13th of November.
Yeah.
The next regularly scheduled meeting, but maybe, I know, maybe we can do something 23rd or 30th?
Yeah, September.
And, well, and you guys need time to do,
Yep.
to get together and do what you're doing. Mr. Toomey, I just wanted to be clear that, and I know the Rules Committee doesn't have a standing in this, but I would hope that the Law Department would take into consideration the position that we have advised, and that is that you be allowed to move forward under current law.
I would appreciate that.
And then I see Mr. Gutwall's hand to tell me, no, you can't do that.
It won't, I mean, I understand, and we're all good with that, and as Brian knows, I encouraged him to do the community meeting because I didn't want to get him caught up. And I've been encouraging everybody else, just do it in case this, you know, you get caught up in this. The issue, in particularly with Brian's situation, is that if the amendment that Rob is proposing, he's one of those tweeners that's caught between that 035 and 014. So 014 doesn't retroactive. He goes forward with his process. Let's just give you an example of just the practical implementation of all this is what I'm trying to bring to you. We could have this thing all queued up for the Board of Appeals. Go to the Board of Appeals, this law passes without the retroactivity, or with the retroactivity, he has to go back to the Planning Commission after we've already signed off on this, is my question, is how this can get caught up, and because what he's talking about a hardship is that he would be all queued up to go to the to the Board of Appeals, because he has to go to the Board of Appeals. Does he also, once that's done, have to go back to the planning commission, since he didn't do that? That's would be my question. If he didn't have the final written opinions, all those kinds of things done prior to this bill being passed, if it's not if it is
There's no
retroactive.
grandfather, yeah.
That's,
I'm open to suggestions in terms of my amendment. I just don't wanna be having this open kinda,
I get your
anything
point.
in the pipeline, right? That sets no limit. If there's a better time in the process to specify, I'm all ears, but I just don't wanna have an open-ended
No, I totally get it,
grandfathering,
'cause-
cause that's caused problems before as well, saying anything in the pipeline.
right,
That's not
because
very
Bemby
clear as
Beach,
well.
it's 10 year, that's actually been submitted since 2012. I mean,
Yeah.
it went before that. He just submitted it 2 months ago, you know, and it kind of
Right.
thing. So you get caught between these people who are,
It's not on my
who have moved forward, or are moving forward, and there's ones that keep
Yeah.
sitting on the books for forever.
I mean, that's why
Yeah.
I chose final plat, cause I don't know, that just seemed like a
Oh, yeah.
point that was good, but again, you know better than I, if there's
Yeah,
another.
it would be site plan approval would be the best, but that might solve
It is
some
on
of
there,
their
it is.
problems.
Yeah,
but-
you're telling me.
Yeah, we
Well,
can talk
maybe-
about that.
Maybe
Or you
in
wanna
the
try
meantime,
for
if
the
you could,
23rd anyway, and if not, we'll
if
move
you
it.
had any suggestions about like a better point in time to suggest, I could work that in if, you know, I could wait until the next meeting, I guess, to,
Okay.
propose something and talk to my colleagues about it.
The Urban Institute, are they in here on the 23rd?
Pete, are you in here on the 23rd and the 24th?
With the Urban Institute?
I'm not specifically, but they are here on the 23rd, and on the 24th I am, but not on the 23rd.
Are they interviewing in this room?
They are.
But it's not on
They-
the calendar.
Well, I have, my time is
Do they have
That's-
1:30
No, that's a
that
problem,
day.
because I tried to schedule, they started scheduling a Board of Appeals or Planning Commission. I said, it's not available, ULI's in here. So.
Why
Yeah.
do they have to be in here? Do they have to be filmed?
No, it's just where they scheduled, you know, they're looking for a place big enough to do the meeting, that's all. And
Well, I think our meeting that has to be taped has to take priority. So could you,
It's not even on the.
well, let's tentatively schedule it for the 23rd, if that gives you guys enough time.
So
Which
the
is 2
reason-
weeks from today.
But I mean, I have gone through the process of trying to determine Chambers' availability for other things on the 23rd and the 24th, and I was told, well, Regina contacted Susie Smith about what's scheduled on the 23rd and the 24th in the council chambers. We were told in very certain terms, this Chambers is occupied until 6:30 with that event on both of those days. So we were in a position of having to choose another date for the matter that I wanted to try to get scheduled on those days. So just telling you what I was already told,
So do you think it would be safer to go to the 30th?
probably, yeah.
Well, I mean,
You guys-
it's,
I was told the same thing.
at that point, our next, after the 22nd of October, the next council meeting is like November. We have back-to-back
The end of-
meetings,
yeah.
November to,
So why can't we
12th and
do
the
it?
19th.
Why can't we do it sooner?
19th and 20 something.
Well, we have to give them time to go back and do what we've asked them to do.
What about Thursday the 19th?
No,
It
not the
looks pretty
12th
clear.
is a
Or
holiday.
Friday-
19th of what?
Friday the 19th.
The
of
19th and
October.
then, 26th.
The 19th works for me, I think.
I think the sooner we
No,
can
holiday.
get this cleared up.
Fifth of
I mean,
November.
With the approved.
I'm very distressed about today. It feels like we went backwards, not forward. And I don't know how for the next meeting, we really have to be able to have everything squared away. So if we did it on the 19th, will
Which is
you
a
three
Friday.
be able, would you three be able to do that voodoo that you do so well?
Wait, I'm sorry,
But
just to
earlier, maybe.
clarify though, we have a
Don't do it
meeting
4 o'clock
on
on a
the
Friday.
13th
Kill
of November.
I know, we're talking about October.
We're in October.
I know, but that's before the next council meeting anyway. Are you looking at
I
trying to
think
schedule them
we're
before
getting
the?
backlogged. We have got so much legislation we got.
I agree. So you're looking for a meeting before the meeting on the 22nd?
And out of,
Okay.
yes, like, say 2 o'clock, or given how long these go, 1 o'clock Friday the 19th?
Oh, and you're talking about in preparation for the meeting on the 22nd?
No, I'm talking about to finish 01418.
But to present to the full council on the
Yes.
22nd?
Right.
Well, that's a Friday evening. When is, I'm not sure that's enough time to get the documentation
Takia
together to
can't-
present to the full council.
Takia can't do
Well,
the
unless it's
19th
early.
either.
Hmm?
She can't.
Unless it's early
What about,
on the 19th.
Oh, you
what
can do it
about
on the
the
19th?
morning of the 18th? We have a work session.
Can I be excused for about 2 minutes to get my work calendar downstairs?
That was
Sure.
Okay, thank you.
No, you can't. We're gonna just,
I mean, I could, if need be, I could try to do something around lunchtime on Friday. I mean, I'd have to take off some time.
well,
but,
is it better for you with work if we do it on Thursday before the work session?
Would you have your meeting, your committee meeting?
We could do 1 o'clock that day,
on Thursday?
on
Mhm.
Thursday the 18th.
I can't do
I mean, if need be.
You can't do that?
I'll have to take off time.
Pete,
I can do
I
that.
can do 1 o'clock on the 18th.
yeah. Well, let's hold that,
Isn't environmental matters at 2 o'clock?
It's on the
1:30?
no, that's the
17th.
17th.
Oh, that's the 17th.
Finance committee's the 17th.
Which, you know,
Let's face it, you need to quit your job and go to law school.
We could use a good environmental lawyer, my law
Right.
firm, Mr. Savage, so.
There's not enough of them around.
I'm not gonna put it on the calendar, Takia, I'll let you put it on once we set the date, because it'll duplicate.
oh, yeah.
So are we tentatively thinking 1 o'clock on Thursday?
Yeah.
I'd also like, I mean, on Thursday, I mean, I'd like to also propose that we have a joint meeting to deal with some of our other
Oh, with
legislation.
environmental, that's on,
It's on the
but that's
17th.
on APF, right?
Well,
Is
we
it
have a
on
work
this?
session on APF on the 18th.
Right,
The
So-
17th Environmental Matters
right.
is doing a joint session on our other legislation.
Well, I'd rather
one?
do it after the work session. Don't we have, isn't that the subject of the work session?
No, the work session is APF.
Yeah.
Right, I thought that's what he was
This is-
talking
No,
about.
no, Environmental Matters is just the other legislation we have, the no-net loss and the stormwater. Because we're gonna be talking about it on the 17th anyway. And Ross and I will be there anyway.
Right, so that's the 17th at 3.
Well, we have to check with staff, because we need 2 recorders, don't we, Takia?
Yeah,
Yeah,
Is that how we did it the last time?
yeah,
yeah, because each committee has to
have
vote
their own.
separately.
Obviously, there's another committee ready to come in here. Okay,
This must be a heavy
So-
calendar.
but we're tentatively looking at 1 o'clock on the 18th,
That's what I put on my calendar.
with the understanding that we'd look to get it on the agenda. We'd have to do that by, what, 16th to get it on the agenda for the 22nd?
Well, I would do it, it would be released on the 12th with the rest of them.
Yeah, we can
What
just
do you mean, released on the
tentatively
mean your
put it on
agenda?
there. Yeah.
For the
For the
22nd
council
meeting,
meeting.
council meeting? When would that agenda be finalized?
She does them on Wednesday.
So that's the following, that's the 17th.
Well, we can put a placeholder, and then as long as everything's posted by Friday in terms of all the materials.
Yeah,
If
I
that
mean,
gives
we'll do
staff
the
enough
color
time to-
coding, amendments, strikes. all
Gary,
that in
we're looking
014,
at the
18.
18th
But
at
we
1
might gotta come
o'clock,
up with the language on that, F.
prior to the work session.
That's
Gary,
your,
did you bring a piece of paper up here or your calendar? Okay.
The 18th and the,
It's a Thursday of October,
the
next week.
1 o'clock.
1 o'clock, okay.
Get shit right.
You got a work session afterwards, right?
Yes, that would be okay.
okay.
Okay, so that's our,
Alright. So
next
our,
rules
so our
committee, the
job is to
18th
get
at-
E and F squared away, that language.
Oh, okay, wait a minute,
And then
one more
I'll try to do the one
recorders, camera.
01418 as amended with color coding and all that to make it understandable. Okay, but, you know, soon, okay, yep.
Okay, so it's 1 PM on the 18th?
Yeah, we
Yes.
have one more, thing to check with the camera, recorders to make sure they can do the job.
Okay.
Are they working now? Are they responding? Oh, okay. Oh, that's right. They're recording us now. Hey, are you guys available on?
You said 1 o'clock.
Yes,
Okay, so the 18th at 1 o'clock. Here's a go.
Okay.
All right, sorry, Brian, we're as frustrated as you are, believe me. We might not have as much money tied up, but we certainly have intellectual capital invested in this.
No, I understand. I mean, like I said, I'm just trying to get the process finished.
We get
And,
it.
and we already had that delayed with the Board of Appeals on the shared parking. That was a 7-month delay, which was not my control.
Right.
Not in my control at all. So this has been, I didn't expect to be behind the shopping center project, which I am right now.
I warned you.
Yeah.
But thank you for coming
Yeah.
out today.
Thanks for
Yeah, we
having
do
me.
appreciate your participation.
Yeah.
It helps us know what's going on.
So,
But we don't
Um,
appreciate yours, Pete.
Just so you know, the zoning code updates, I have a number of people that keep asking me about that.
Oh, 19?
And so will that
Is
be?
your mic on?
Huh?
Is your mic on?
Yeah, I think so. So, 1918, yeah, there's a number of zoning code updates that constituents keep, asking me when it's gonna be taken, and that has been on your agenda at least 3 times. So will that be taken up on the 18th as well? Because they'll ask that question, I'm sure.
Pete, how detailed, and I don't recall, because it's been.
There's a lot to.
There's a
19.
lot in there.
Okay.
I think it's pretty straightforward. I mean, I know there's a couple of pieces that may not sit well with some people, but to me, it was clarifying. It's a lot of housekeeping. It's simplifying some processes and procedures. The biggest issue is allowing people to ask for a variance. That is what the people that came and spoke at the city council meeting, the Sweetics,
Mm-hmm.
that was their issue. They can't even ask for a variance because because the code prohibits them from asking for that type of variance. So, I think it's to me, it's due process that they should be able to at least ask. And that's why we're recommending that change. But there's a host of other things that are in there so that probably, will be part of a discussion. But I just wanted to know if it would be discussed on the 18th, because I'm sure that'll be the email tomorrow morning. And will it be on the agenda, or will it not be till the November?
Well, would it be helpful if maybe we started at 12:30 and dealt with that first?
Oh, no. Let's get 14, 18 done, please.
Well, I'm hearing
Yeah,
Pete
'cause
saying there's a.
I just want to know if it's going to be on the agenda, because you had 2 other pieces of legislation, I think, that it's scheduled for
I would like to
today.
get to it, but I think, Pete,
Ethics code
I
is
tried to
better.
get Bob Waldman to come, because the planning commission made a lot of changes, recommendation, amendments, and there's no rationale. I mean, I'd like to know why they made all
I
those
could
changes.
speak to that. I think,
Okay,
I mean,
all
Mark
right.
Rodriguez
And
asked me the
and
same
I,
thing,
you know,
Rhonda asked me the same thing.
Right, Mark
She doesn't
is-
agree with they're 2 of them, 2 of their constituents are part of this process, and they both asked, and, they don't agree with it. And I think they both sent you all emails as well as full council that they didn't agree with the planning commission's recommendations. I can speak to them and why they recommended it. I know what their rationale was, I think, for the most part, but,
So clearly, that's going to be a larger discussion,
yeah.
a longer
Well,
discussion.
That might be longer
The
than the
discussion
discussion about
of-
the
Yeah.
014.
The discussion of 2138 is gonna be long.
We might be able to fit both in that meeting.
This one's 21/8.
We could pull that
We
out
might be
with
able to do both at that
legislation.
meeting, the next meeting.
Well, should we put it on the agenda after 014, and if we get to it, or at
Okay.
least maybe we can begin the discussion?
Yeah.
I just wanted to be able to, I know it's gonna be emailed tomorrow morning.
Yeah, no, believe me, we go through that same
Yeah,
thing,
so
so
I
we
just-
understand.
Wanted to know what the full agenda was. If it was just 014/18, I'll tell them that. I mean, that's fine, but,
But it'll be after 1418.
okay.
The ethics code, 037. Is that a lengthier discussion? Gary, do you know?
I think that's pretty
I can't, I
financial
really can't answer
disclosure
that.
update.
Yeah, it's hard to
Hacker.
answer that question,
Okay,
I
so
know.
we won't even try. So we'll
Yeah.
just
Yeah,
put
let's not do that.
014 and 019 on the
Yeah.
agenda for the 18th.
Sounds
Okay.
like safer because of the way things have been going over the past few meetings. You just get into extended conversations about things,
Mhm.
so it's probably all you're gonna get done anyway, you know.
I'm
Okay.
sorry, Gary, did you say, so,
Yeah.
are you saying, that it's not much discussion on the ethics, or that you're not prepared right now
It's
to
hard,
talk about
it's
it?
hard for me to predict that, but, you know, just based on the way the conversations have been going the last 3 meetings on 3 pieces of zoning legislation, and we've gotten 1.5 pieces of these 3 legislations. We've gotten through about 1.5, I guess you could say. So I'm anticipating that on October 18th, it's probably gonna take more time than we have. Although, if you wanna schedule it, we can,
Well, I mean, I was just gonna throw out, I'm willing to talk about it now.
one
We
are
have
you
a little,
talking about?
little bit of time. The ethics code, 03718.
but it's not on the agenda,
It's
is
on the
it?
agenda for
Oh,
today.
it's on the
is,
agenda?
yeah.
But
Oh.
it's something that I think Rich Melnick put together. I mean, I'm good with what was proposed. I wonder if we could just approve it, recommend it, and get it out the door.
I have not focused on it, but I can look at it quickly.
Yeah, there's not much to it.
But doesn't this speak to
I gotta get it.
the housing authority and,
It's basically, my understanding is it's kind of just a cleanup of the code about something that was raised with the city attorney. So, let's see.
so,
I'm
for-
reading the staff report.
I don't- I need to
so
get the
this
copy
would
of the
require
result
that the Board of
legislation.
Commissioners of HACA be
Okay,
required
thank
to
you.
complete.
Thank
Thank you.
It says it's the result of legal interpretation provided by city attorney Richard Melnick to the City Ethics Commission. So it's just something that he thought needed cleaning up.
Yeah, but
How do they
I
feel
think
about it?
there's, right, there's more discussion because it requires HACA's board, their executive director and their deputy to file.
What they did already, if you look at the code, he basically just, let's see, he strikes, where is it? At the very end, he strikes a provision, it's called section 2852 on page 12, that talks about financial disclosure for the housing authority of the city of Annapolis.
But if you go back to page 9, it adds them in.
Right, so it's more just a cleaning up of the code as opposed to just putting anything new in there.
I just can't imagine Beverly.
That's what I'm thinking. I don't think we should rush to approve it without them being aware. And
She and
when it-
Shanika are having enough of a dust-up on
I
other
know.
things. I just,
When this comes back to the agenda, would you make sure that HACA is invited?
actually, for all of our committee members, I think we really do need to have relevant staff or other people there.
Mr. Elson, we're talking about the Housing Authority being required to submit financial disclosure.
Right, I just don't have the legislation in front of me, and it wasn't in the back, so
Yeah.
if are you going to take a more thorough look at it right now, or?
I don't think we're gonna act on it tonight, because I think the Housing Authority representative should be here.
Do you know if they've taken
I-
a look at it, Gary, or?
I'm sorry,
Do
Rob.
you know if they've taken a look at this legislation?
I
or-
don't know.
Okay.
I couldn't answer that question. Rich may know, but, you know, Rich was not in today, so I can't even, indicate what he knows about it. But I do agree that if it affects the housing authority, that, their interests should be represented,
Yeah.
yeah.
Yeah, for a number of reasons. I mean, the mayor seems to have taken on a more unilateral relationship with the housing authority, particularly Beverly. It used to be that the council was involved in those things, but does the mayor know about this legislation?
I couldn't answer that question.
I wonder
I
if you
would
know.
tell you if I knew, but I don't. But I think that, you know, the council generally has control over the board of directors of the housing authority, and I think that, and we get quarterly reports, I think it is, from the housing authority. They come in either during a work session or some other type of, you know, calendar event for the council. And you know, so the council generally does not have a lot of control over the housing authority, although the council has extended the courtesy of being involved in housing authority decisions, and so if this has come before the rules committee here, I think the bottom line is that the housing authority should have an interest, their interest should be represented here.
We don't have authority over the Housing Authority Board. We do appoint, but we don't have authority over.
Not over the activities of the board,
Okay.
the persons who are on the board.
Right.
Yeah, that's what I meant, yeah.
Elected officials have to complete financial disclosure forms. And this is a question, I guess, for later. How do we hold them accountable when they don't answer to us? What's the repercussions if they don't submit?
Submit financial statements, you're saying, if they
Yeah.
don't?
Yeah.
It goes to the Ethics Commission.
And then what?
The Ethics Commission would determine whether the application, or not the application, the statement is complete, and if not complete, would require that it be completed, you know.
But again, suppose they refuse to submit a financial statement. What's
We've had-
the Ethics Commission gonna do?
We've had that come up,
Well,
not just with, with
Well, we
staff.
have control over the Environmental Matters Committee,
But
though.
we're the
They
ones who
said
confirm
person couldn't be
new
on there. We can't
Well, yeah, I'm saying we
pull
don't have to
people off
confirm
of
it
the,
if they don't.
I don't think the council can, but the repercussions for not submitting a financial statement is that they're in violation of the city code, and, you know, conceivably could be removed for failure to submit a financial statement when the code requires it. I mean, it
I
could
want tickets for that show.
Yeah, I'm said, that's why I said conceivably.
And they don't have to submit their ethics disclosure until after they've been appointed to the position, right? Because we changed that
yeah.
a couple of years ago, right?
Yeah.
And they have a year or 6 months or
It
something.
depends on when their appointment is,
Do we wanna keep it?
because they're due, I think they're due on March 31st, I believe, the financial,
January.
is it January 31st that they're due? Yeah, it is January 31st, so it depends on when they're appointed. There is language in the code which says that, you know, if they're appointed at a certain time, then it's the next year when they have
Right.
to produce the financial statement, the disclosure statement, so. But, you know, when the Ethics Commission's responsibility is to determine if there's, you know, if the person who is responsible for submitting the financial disclosure statement has a justifiable reason or a code allowable reason to not complete it or not to submit it at all. And, you know, if the commission makes a decision, the consequence is possible removal from the position because they're not in compliance with their financial disclosure requirements. So it's not a situation where it's just a determination is made and nothing is done about it, you know, so.
Madam Chair.
Yeah.
So I'm just wondering, is it's mentioned in here that the city attorney, sounds like they provided this to the Ethics Commission, but I don't see anything from the Ethics Commission. Have they, or can you find out if they have seen this, if they have any, if they concur, maybe, or do you want to, Madam Chair, do you want to?
I can find out.
Invite them to the next meeting, or?
I think we should invite them to, and have the answer also, if we can actually hold them accountable for their ethics, their disclosure forms.
Do you want Jim
Uh,
Dolezal here from the Ethics Commission?
Well, it's his legislation, I guess.
Well, if
Seems
they
like-
have something,
I would assume that they
say.
made a recommendation to the mayor, and that's why it's legislation.
I'm
Or
not sure
maybe
exactly how it
that's
was
not a
generated,
good
but
thing to say
I
it's
think
an
it came
assumption.
from, 'cause some of this, it looks like, in the staff report, some of it came from the state, which are some of the changes about, information you have to provide when people request, to review these disclosure statements. And the other section, it sounds like came from the city attorney. So I
Well,
guess it'd probably be helpful to hear from.
yeah, we have to, you know, whenever the state revises the ethics laws, we have to revise our laws.
Right.
you know.
Mhm. But this must be new, because we just revised our code
Yeah.
based upon state law about a year ago.
Yeah.
So, there must be something
Well,
different.
from what I recall, there may have been some things in there that, Ethics Commission was trying to maybe perhaps do, or maybe we did, I can't remember, above and beyond what was recommended by the state, and maybe this is just kinda,
So it says
Reverting back
this is
to,
requested by the Maryland State Ethics Commission.
Mhm.
So it came from the state
Mm-hmm.
to us.
So,
Um,
so it's maybe not our, Mr. Kozol who's,
yeah.
yeah, I don't think it is.
But
Promoting
if you want to hear, what his comments are on it, I mean, we may have no choice but to, do what is consistent with the state. And that's why this is being presented to you, but, and it may be, if that's the case, then Mr. Dozal's appearance here might not be something that he needs to do.
But years ago, and we may want to reaffirm that because it's been a few councils, we made the ruling that we were not going to do legislation that we had no control over. And we were not going to do resolutions asking the state to do something, or the United States, or Russia, or whomever. And
I don't think we ever made that official though, because we've done.
well, I know,
plenty
well,
of
we
that.
have done some, but I mean, I just question if we put this in here and the HACA board says we're not gonna do it, other than muddying the water in our relationship with them, what are we gonna do?
Well, I think that's why it's important to have them in the room. Because if the Maryland State Ethics Commission is telling us we
Think
have
we
to
should
do
have
it,
them in the room
they
too.
should hear, what we're being required to do. That it's not us initiating this, but it's the
I
state.
don't wanna
Sure.
even be near it.
Well, if I could suggest, maybe we should just touch base with the city attorney, because I think he may be able to answer all these questions.
And that's why we're doing it.
Yeah, I can talk to, Rich Melnick
Yeah.
about it, what just was discussed here, and then, is it gonna be on the agenda then for October 18th?
No,
No.
It will not?
No.
Okay.
we shouldn't even pretend that we're
No.
gonna get to this.
We'll try to get you
So
some answers so that you know what you're
Yeah.
dealing with here.
Yeah,
Okay.
Okay.
but we should put it on for the meeting
November.
after that, the regular
your November meeting.
November meeting.
Okay.
All right, what about the joint meeting with, Environmental Matters?
Oh, yeah.
Do we have our
Yeah, I
agenda
would like
for
to
that?
move that we do that on the 17th,
Trying
because
to-
we have joint legislation, and we can kind of take advantage
don't
of all the
even-
people at the same time.
We don't even have that up yet on our,
The agenda?
Granicus.
Environmental
Yeah, no,
Matters
not
is
yet.
on the agenda. I'm
Where?
gonna wait until we hear,
When did someone propose?
it's on the agenda for the
Oh, he's
17th.
saying environmental matters isn't on Granicus yet.
How do you get the 17th? I don't have the 17th though.
For the
It's on my
Environmental
phone.
Oh,
I
but
just
it's
have
not
it.
in Granicus. So I don't know what all is
Oh,
on the
okay.
Environmental
It's in
Matters.
there?
Oh, no,
Okay.
agenda is not.
The agenda's not, but the meeting's on there for 17th, 3 p.m. Yeah, no, that's, yeah, that's fine. I still need to confirm the agenda with you too. But I did request, I know we're gonna have on there the no net loss and the stormwater. I think those are the only two pieces of legislation, so.
And they're also assigned to rules?
And they're also assigned to rules. I thought we could just do it all at once.
Well, if staff can accommodate us, we need 2 staff people here to do that. I mean, I'm available, 3 o'clock on the 17th. So Takia, you wanna, Ms. Green, you wanna get back to us?
We didn't use the 2 people last time, it was just me.
Well, you take 2 sets of notes? That's what we've done in the
No, I had
past.
to
She's worth 2 people.
start-
Right.
I had to start one meeting and then
Start the
stop it and then start the next one.
Yeah, that's
And
right.
that's how I did it. It was just me here.
Okay,
As long as Regina doesn't get on my case about it.
Hmm.
because the next time she's gonna, I'm not
I
gonna.
have to we have to do, I think she has to do a whole.
Well, confirm it, we'll tentatively schedule it for a joint meeting. I know we can't even use that term, because that's not accurate,
Well-
because it's not joint. It's, is it, but I thought it was 2 meetings concurrently or
Well,
something
can
like that.
I-
Anyway,
Could I
could you check?
officially move to do that?
Well, I
if
don't think
the
you need to
schedule
do it.
allows?
We've just, you know,
Okay.
yeah.
Okay.
So, but, get back to make sure. Well, it's tentatively scheduled.
And I can coordinate with you in terms of people we would like to interview, if you'd like.
Interview?
And just so if we want people to talk to at the meetings, because I was planning on inviting some of the staff, like Director Gerald, to talk about some of the stormwater.
For your, okay, for your, okay.
Right.
Then
And so-
you let me, just, yeah, let me know who you've invited.
Okay. Yeah.
That's fine.
Is
Okay.
Jackie coming? Kyle's?
Yeah,
Sure.
she comes to all of our committee meetings. But if there's anybody else, I think it
And
would
law
be good to.
department should be there.
Yes, they're on my list too. The 17th, it's the regular environmental matters committee meeting.
3
3.
o'clock.
Yeah, it was on my list. I don't know if I've emailed them yet, but I was going to invite somebody from the law office. Because the same kind of grandfathering questions are going to come up on that one. I mean, different circumstances because legislation is different, but same kind of.
Okay. Anything else for the good of the order?
We need red tape.
You know, Ms. Green, the next time this is sitting up here doing a council meeting, I would like for you to come over and take it down. You know, we have no sense of etiquette here, I'm just saying. Decorum, you're right, okay.
Rich is the sodas that he leaves out.
Movie adjourned.
Is there a second?
Second.
All in favor, please say aye.
Aye.
Meeting's adjourned, thank you very much.